All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KC-BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you. Today we will continue to hear the evidence of prosecution witness W04576. I note that Mr. Krasniqi is appearing by video link today, and the other accused are present in court, and Judge Barta is continuing to participate by video link. Excuse me. Madam Court Officer, please bring the witness in. We will briefly break at 10 o'clock as we did yesterday for 10 minutes. Go ahead. Madam Court Officer, you have the floor.
Your Honors, just a clarification. Yesterday, 3 admitted exhibits for the Krasniqi defense with exhibit number 4D26, 4D27, and 4D28 are all classified as confidential, so just to rectify that on the record.
Do those need to remain classified as confidential? Mr. Ellis, those 2 of those were your exhibits?
At least 2 of them have a name on it that could be associated with the witness, so I would have thought that confidential would be safer.
Thank you. And the others is from the SBO, the other witness?
Yes, the other exhibit is 2 pages of the book 043900 to 044239, which were admitted as P01014, and they're all marked as confidential. The book is marked as confidential.
We'll check with our colleague and get back to you, Your Honor.
Thank you very much. Good morning, witness. Thank you for being with us again today. I remind you during your testimony that will continue now.
Good morning.
I remind you to please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them that you don't understand, and they will clarify. Also, please remember to try to indicate the basis of your knowledge of the facts and circumstances upon which you will be questioned. I remind you that you are still under an obligation to tell the truth as stated by you in your solemn declaration. Please also remember to speak into the microphone and to wait 5 seconds before answering a question to allow the translators to catch up. If you feel the need to take breaks, please make an indication and an accommodation will be made. So we continue with the questioning from the prosecution. Mr. Potch.
Thank you, Your Honor. And just to correct myself, the exhibit P01014 was actually one that I admitted yesterday, and that can be public.
Thank you.
Good morning, Mr. Witness.
Good morning.
Yesterday, where we left off, we were discussing the area of responsibility of Brigade 162. And on those lines, my next question is, could you tell us where Kukai is located?
Kukai is a neighborhood in the commune of Kačanik.
And was Kukai under the area of responsibility of Brigade 162 in 1998, 1999, or both?
Jo,
No, it was not under the control of the units because they were located in the mountainous part of the area. And I'm talking here with regards to the brigade units.
And how far is Kukai from Bob, from the village of Bob or the mountainous area above Bob that you described yesterday?
është lagje e fshatit.
It is a neighborhood in the village of Bob. It is about 2 to 3 kilometers the mountains are 2 to 3 kilometers over the neighborhood of Kukai.
And in 1998 or 1999, were there any KLA units in Bichech?
Në vitin 90
In 1998, no, there were not.
In 1999?
në vitin
In 1999, there was a company.
When in 1999 was there a KLA company in Bichech, please?
nga fillimi i
From the beginning of April. About the date, I can't exactly recall.
And who from the KLA was in charge of that unit in Bichech?
ishte komandanti
Nazmi Osmani was the commander of the company.
Was Varosh under the control, or within the area of responsibility of Brigade 162?
jo.
No.
Is in the Ferizaj municipality, is that correct?
Po në komunën e
Yes, it is in the commune of Ferizaj.
Where did Brigade 162 have any areas of responsibility in any other part of the Ferizaj municipality in 98 or 99?
në vitin 98
In 1998, no, there was no area of responsibility of that brigade.
In 99?
në as 99
That is true for 1999 as well. So there were no responsibilities of this brigade over the area of Ferizaj.
Where is Jezert or Jezerte?
fshati Jezers ndodhet
The village of Jezerts is located in the municipality of Ferizaj.
And how far is Jezert from Varosh?
sakt nuk më
I don't know how far it is exactly. I can't tell you in terms of kilometers. I don't know.
Do you recall telling the prosecution when we met for witness preparation that it was 12 to 13 kilometers away from Varosh? Does that sound correct?
mundet me qenë pavarësisht po
It can be approximately that distance, but I can't tell that for a fact. Because Varosh is at the very beginning of the territory of Ferizaj, whereas Jezert is totally on the opposite direction.
And were there KLA units in Jezert at any point in 1999?
cilat njësi ju lutem?
What units are you talking about?
Any KLA units in Jezerts in 1999?
Jezerci nuk ka qenë kompetent.
Jezerts was not part of my competences or powers.
I'd like you to listen to the question I'm asking. Were there any KLA units in Jezerts in 1999 to your knowledge?
Ka pas, por nuk
Yes, there were, but like I said, they were not under my powers. And I can't be accurate in my answers for something that was not part of my responsibilities.
To your knowledge, under whose powers were the KLA units in Jezerts?
nuk më kujtohet.
I do not remember.
Yesterday, towards the end of the day, we also discussed Ivaya. Could you tell us what buildings or structures the KLA occupied or used in Ivaya in February and March of 1999?
Po ka përdorë në për pjesët e
They used areas and houses in the mountainous part of that area.
And in relation to the houses that the KLA used in Ivaya in February and March 1999, do you remember who owned those houses before or when the KLA used them or occupied them?
nuk më kujtohet.
I do not remember.
Now, turning to Bob, or the area above or around Bob, what buildings or structures did the KLA use or occupy there in February and March of 1999?
Ka qenë në pjesën mal.
There was a house in the mountainous part of the Bob village. It was an old house, a house that served to summer businesses, to farmers. That was a house that was used by the KLA.
And yesterday you told us that it was Ferris Guri's company that was based in the area above Bob. So is this the house that this company was based in or used?
Po,
Yes.
Turning to Bicech, could you tell us what buildings or structures the KLA used or occupied in Bicech in 1999?
nuk jam I sigurt se nuk kam
I am not sure because I have never been to that house. What I can say is that it is recognized as the neighborhood of Żarku.
So in your answer, you said you've never been to that house. In response to my question about Bicech, what house have you never been to in Bicech? What are you referring to?
por ato që pyet edhe ju.
For the house that you were talking about, it was an answer to your question. I told you that I don't know in what house they were located, but I know the neighborhood, and the neighborhood was that of Żarku.
Witness, just to be clear, I didn't refer to a house, I just referred to buildings generally. Am I understanding correctly that, to your knowledge, there was a house used by the KLA in the Żark neighborhood of Bicech?
Jemi keq kuptu, si godin.
So the building, a building or a house is the same thing to me. About the house where they were staying, I can't say anything about that because I haven't ever been to a house or to a building, no matter on how you refer to it.
Did you ever visit Bob or the area above Bob Mountains in 1999?
Te Kula Hasanit po.
I've been to the Tower of Hassan. There is the place where I've been.
And is the Tower of Hassan the same location that you mentioned the unit of Ferris Guri was based in, or is it somewhere else?
I njëjti vend.
It is the same place.
And was this Tower of Hassan the place where Ferris Guri's unit used? Was there anything particular, or was there any particular reason why you went there at the time?
Jo, nuk isha
No, there was no particular reason, but I was the deputy commander, and there was the place where they would cook the food for the soldiers.
And which soldiers was the food cooked for in this area of Bob that you're just referring to?
Në Kullën e Hasanit përgatitej ushqimi për ushtar.
The soldiers of the company of Ferris Guri would take food from the Tower of Hassan, so the food would be cooked there for the soldiers of Ferris Guri.
For not part of Ferris Guri's unit, correct?
Jo,
No, I was not.
Okay, so like yourself, were there soldiers other than those in Ferris Guri's unit who also went to this area for the food in 99?
nuk më kujtohet sakt.
I don't remember, but nobody was prohibited to eat food. The food was accessed by everyone.
I'd like to show the witness a document. A court officer, please, can we call up 036622 to 036837, and we'll show the first page of that, please. And side by side with it, the Albanian version, which is 077039 to 077258, and again, the first page, please. Thank you, court officer. Witness, do you see two documents on your screen?
Po.
Yes, I do.
On the left is in English, and the one on the right is in Albanian. Do you recognize these items?
Po, të dyja.
Yes, they are both my books.
And you said that they are both your books. Is it correct that you yourself wrote the version in Albanian?
Po.
Yes.
The version on the left is the English translation of that book that you wrote yourself?
Po.
Yes.
Court officer, on the item on the right, could we please turn to the second page, 077040? We can leave the one on the left on the screen for now. And witness here, and just focusing you on the item in Albanian on the right of your screen, we see at the bottom, Pristina 2012. Is that when you first published this book?
Po.
Yes.
So you published it in 2012. Could you tell us when you started writing the book?
Sakt nuk muj me
I don't know exactly when, but it was about 4 to 5 years before the publication. It took me 4 to 5 years to write the book.
And as soon as you finished writing it, was it published, or was there also a break in time or a lapse of time between the time you finished it, writing the book, and then when it was published in 2012?
Jo, në moment që e kam përgatitur
Once I wrote it, I published it immediately. There was no lapse of time.
And do you remember in your SPO interview telling the prosecution that you needed 3 years after you prepared the book for it to actually be finalized and published?
Po, unë po them se 4-5 vite më kanë shku.
Well, what I'm telling you is that it took me 4 to 5 years, and the 3 years you're talking about are part of these 4 to 5 years.
And court officer, could we please turn to page 36624 in the English version on the left, and in the Albanian version to page 077041. Thank you, court officer. And witness, as we can see on this page, is it correct that Professor Dr. Selim Thaçi and Major General Shukri Buya were the editors of this book?
Po,
Yes, they were the editors of the book.
Briefly, who Professor Dr. Selim Thaçi is?
Profesor Thaçi është
Professor Thaçi is a professor with the University of Pristina. He is a history professor.
And court officer, I'd like to turn to pages 36637 in the English version, 36637, and in the Albanian 077054. And witness, this is from your own introduction to your book, and you state as follows, quote, I am especially grateful to the reviewers, Dr. Selim Thaçi and Major General Shukri Buya, whose suggestions and critique increased the scientific value of this publication and gave me courage for future studies as well. That's the end of the quote. And witness, my question is, could you tell the judges what Shukri Buya's role as an editor of this book entailed?
He gave his opinions about this book. Even though I said yesterday, and I'm repeating it today as well, that we presented things according to our own wishes rather than as they happened in reality. So we have augmented things. I told you that yesterday as well.
You said Shukri Buya gave his opinions about the book. What opinions did he give you?
Mendimi që është në libër.
The opinion that is there reflected in the book.
And do you recall what that opinion was by Shukri Buya?
Jo, përmendsh nuk.
No, I don't remember it by heart.
Recall Shukri Buya giving you an opinion that anything in your book was incorrect or not accurate?
Krejt çka e ka thonë Shukri Buya është.
Everything that Shukri Buya said is reflected in the book itself.
Yes, witness, you're not answering my question. My question is, when he gave you his opinion, or let's say when he spoke to you about your book, do you remember Shukri Buya telling you that anything in your book is not accurate or not correct?
Nuk më kujtohet.
I don't remember.
Is that you don't remember him telling you anything is incorrect or anything is inaccurate, or are you saying something different?
Nuk më kujtohet.
I don't remember. Everything that he said, those things are in the book.
So just to be clear, you don't remember Shukri Buya ever telling you something you wrote is not correct, not accurate. You don't remember that, right?
Nuk më kujtohet.
I don't remember that.
Court officer, if we could please turn in the English to page 036629 and in the Albanian to page 077047. And I'm reading from the last paragraph in the English and the first paragraph on that page in Albanian. And witness, here we see some words written by Professor Thaçi, including, and I quote, the following. The author used as resource and based this monograph on many authentic documents, orders, reports, and studies, which remain not catalogued in the archive of the area of operative Nerodima, Area 6 of the Kosovo Defense Army, and the Kosovo archives, mainly in the Kele area. These numerous documents depict a clear tableau, the most important events of the Kele War in the area of operative Nerodima. Original data abound from the facts, interviews, memoirs, and conversations with the Kele leaders in the area of operative Nerodima. The author has also used the media of those times as an additional means of verification of the data, further increasing the professional and scientific value of this monograph. That's the end of the quote. And my question, witness, is whether the information by Professor Thaçi here in his introductory remarks is correct.
Profesori është bazu në ata që
The professor was based on what he saw in the book. Nonetheless, I wish to repeat once again that we have embellished things, and that is something that you have to take into account.
So, witness, could you just clarify that? Was the professor lying when he wrote that about your book, or was he being truthful?
asnjëherë nuk ka gënjur.
The professor has never lied. He doesn't lie. He's not a liar. Please don't formulate it like that, because like I said, the professor has given his evaluation based on what he has seen in the book. So the things that I've written myself, those things have been embellished, they've been augmented so that the book was the most interesting possible. So we have put things the way that we wished, not as they were in fact.
At this point, I'd like to admit the pages that I've shown to the witness thus far from the book. I could repeat those if it assists. They would be pages 036622, and in Albanian 077039, 077040, 036624, and in Albanian 077041, 036637, and in Albanian 077054, and 036629, and in Albanian 077046-247.
At this point, we would object. We're not sure what the relevance is until something is going to be put to him about the book, given objections we laid out yesterday, we'd like to see what the rule is that if other portions of the book are going to be offered, we think it should be offered together. But until we see what the purpose of the book is, we can't make give an opinion on whether this should be a part of what ultimately is coming. So just to put a title of a book in and some comments about the value of a book, but then not put anything from the book in, I'm not sure what the relevance or probative value is until we see what's coming from the book.
We support that position.
We also support it, Your Honor.
Yes, Rob.
The enumerated pages will be admitted as clearly relevant to the book and to this case. They're authentic. There's a probative value. So they will be admitted, and will the court officer please assign a number to them.
Your Honors, page 077039, page 077040, page 077041, 077054, and 077046 to 47, Albanian version, and their corresponding English translation will be assigned exhibit number P01015, and just to mention, the pages are extracted from the book with ERN 077039 to 077258, while English translations are extracted from the document with ERN 036622 to 036837. And the current classification of the entire book is confidential.
And on that, both versions, English and Albanian, can be public.
Any objection to the public classification?
No.
No separate objection, no.
No, Your Honor.
Mr. Ellis?
Your Honor.
All right. They will be reclassified as public. Go ahead, Mr. Potch.
Thank you, Your Honor and Court Officer. Witness, still referring to the book that's in front of you, did you knowingly include any facts that you knew to be false in the book?
Nuk më kujtohet.
I don't remember.
So you don't remember if you knowingly put in facts that you knew to be false in the book? Am I understanding your answer correctly?
Nuk më kujtohet.
I don't remember. I said it earlier. There are things that I have amplified, I have embellished in there. I have included all those in the book in the way I wanted them to be portrayed and not as they were in reality, because the reality was something different. The circumstances, the conditions were very hard, and I could not represent those in the book as they were.
Sorry, would you have written something in this book that you knew was not true?
Për momentin nuk më kujtohet.
Right now, I can't think of one.
So right now you cannot think of something false that you wrote in the book, right?
Nuk më kujtohet.
I don't remember.
I just need you to be clear in your answer and to make sure I'm understanding. You don't remember writing anything in the book that you knew to be false at the time. Is that correct or not?
Nuk jam gjendje ta
I am not able right now to tell you specifically those things. Therefore, I don't have an exact answer.
Witness, I'm still not understanding your answer, so I'm afraid I have to go over this again. What are you not able to tell me right now? Are you not able to tell me right now that you did not include false information in this book? Is that what you're unable to say?
I do apologise, but I don't even understand that question with its double negatives.
You might want to rephrase that, Mr. Potch. I agree that's not very clear.
Certainly, Your Honor. I could also do this another way and go with your leave to the prior statement. Since the witness is talking about things he doesn't remember, there's a relevant passage there I'd like to go to.
So withdrawing the question?
Yes, I will rephrase it in another way. And so, court officer, if we could please pull up 074301 TRET Part 1 and the Albanian translation as well of the same item. And we're going to go to page 17 in the English and starting at page 20 in the Albanian, please. So, part 1, and we're page 17 in the English. Yes, correct. No, not correct. It's page 17 of the English. I can't see the page number right now at the bottom of the... Thank you. And in the Albanian, it should be page 20. Yes. So, witness, I'm going to read to you from your prior statement to the SPO in February 2020. You see the English version on the left that I'll be reading from, and the Albanian version on the right. And so we have the following exchange.
Please indicate the line number.
Yes, I'll be reading in English from line 13, and in Albanian from page 20, line 9, and it goes on to the next page until line 12. Question. Did you knowingly include any facts that you knew to be false in this book? Answer. No. And witness, we'll stop there. So is it correct or incorrect, as you stated in February 2020, that you didn't include any facts that you knew to be false in the book?
I have said this, however, I repeat again that I am not certain about this matter.
I'll continue reading you in your answer here. You say, as far as I know, I am aware that I wouldn't write something that was not true. Could you tell the judges whether this is correct?
Your Honour, I'm going to rise at that point. It would be helpful if the whole answer could be put to the witness in context. We're picking phrases.
If prosecutor doesn't get to the whole answer, we will ask him to, but let's let him handle the questions as he wishes. Go ahead, Mr. Potch.
Thank you, Your Honor. So, witness, just to repeat, the next sentence here says, as far as I know, I am aware that I wouldn't write something that was not true. Is that correct or not?
I would want the entire sentence to be read.
Please answer that question. We will get to the rest of it when I choose to.
I am not able to give you an answer with partial things. Because if we read the sentence word by word separately in a separate way, it loses its meaning.
The sentence that I read to you, you said you're aware you wouldn't write something that was not true. Is that correct or not? Could you please answer that question?
Can you please let me know the number under which the sentence can be read?
I believe it is being interpreted to you, but if you want to follow from the Albanian, it is on your screen at page 20, line 9. And it goes on to the next page, 21, line 12. But you can listen to what I'm saying. I'll repeat it one more time, witness. You stated in February of 2020, as far as I know, I am aware that I wouldn't write something that was not true. Could you tell the judges if that is correct or not?
Mr. President, just for the record, I'm told that it actually begins on page...
We need to read the preceding sentence when I said...
It begins on line 24 in the Albanian.
Thank you, Your Honor. That may well be correct. Thank you to counsel for assisting.
Witness, listen to the question that's asked and just, witness, listen to the question that is asked and answer it. Don't ask for something that is not in the question. Just answer the question. You will be allowed to clarify anything after you finish that, but answer just the question Mr. Poch is asking at this time. Go ahead, Mr. Poch. Repeat the question.
Thank you, Your Honor. And one more time, witness, if you could please listen carefully. You stated in February 2020, as far as I know, I am aware that I wouldn't write something that was not true. Is that correct or not?
That calls for a yes or no answer. Correct is yes, incorrect is no.
That's correct.
To read the passage, you go on to say, it is possible that something might not be true because I didn't have the proper documentation to support it as well. It is possible I have forgotten some things, or my colleagues, co-fighters, might have forgotten something as well. Is that correct, witness?
Correct.
And we can take... before we leave that passage, could the witness's answer on the transcript be read to its end? There's a further qualification which has been omitted by Mr. Patch.
Your Honor, the further qualification is not relevant to what I'm asking. It's something that the witness has said in court multiple times, and should defense counsel wish to put it in cross-exam to reiterate something the witness said, they can do so.
Yeah, exactly.
Certainly, Your Honor. So as Your Honor ruled, I will read the final sentence of this paragraph. Witness, the last sentence in your response says, but myself, as the author of the book, I would advise you not to rely so heavily on it as part of this process. Is that correct? Does that correctly represent what you said in February 2020?
Correct.
And witness, since the book was first published in 2012, has anyone ever informed you in any way of any particular error or mistake in the book?
Nobody has informed me of any such errors. On the other hand, I did not have time to deal with this in more detail either.
So in the 12 years since this book was published, in Albanian at least, nobody has pointed out any errors to you, right?
Not to me personally.
And court officer, we could go back to the book exhibit, please. So that is in English 036622 to 036837, and in Albanian 077039 to 077258. And we'll be turning to pages 036805 in the English. So 036805 in the English, please. And in the Albanian, that is at page 077225. Thank you. And if on both pages we could zoom in on the photos on the bottom left corner of each page, please. Thank you, court officer. Witness, in front of you are another 2 pages from your book, on the right in Albanian and on the left in English. And we are zooming in on an image there. Do you recognize the location in the image depicted?
Yes. And this is the Kula Hassani, the dwelling of house of Hassani above the village of Bab.
It's the location where Ferris Guri's unit was based in 1999, as you mentioned.
Yes.
And we see a timestamp on the image. To me, it looks like 13/3/1999. To your knowledge, would that be correct?
It is possible. However, I am not able to confirm this with certainty because this was extracted from a recording, and sometimes there can be technical complications as a result of which the dates are not correct.
Caption to this photo, just for completeness, says the headquarters of 162nd Brigade Agim Bayrami at a work meeting. Then could you confirm that that caption is correct?
Some of the members of the command, and I'm one of them.
Are you at the meeting in the image, to your recollection?
Yes, I am.
Do you remember what that meeting was about?
I don't know exactly, but in this house where Ferris Gur unit was stationed, this was as a point where all the volunteers would go to join the Kosovo Liberation Army in Gachanik. And because my duty, my task was to prepare the new recruits, to teach them and train them how to use weapons and ammunitions, and to prepare them for their soldiers' tasks and duties and combat operations, etc. So this must have been, the content of this meeting must have been related to this.
Attended that meeting?
I don't exactly, and I am not able to distinguish from the photograph the individuals there.
But you would go sometimes to this location because there was where you could get food from. Could you clarify whether the kitchen, as you described it, is in this building that we see depicted in this image?
Yes, the kitchen was in this building.
And, Your Honor, I would seek to admit this image, but I'm told that it has already been admitted as P01002 as an associated exhibit to another witness, so I won't. If the court officer could confirm that later, that would be good. And if we could kindly turn to another book by the witness, so it's a different ERN range, and that is 043900 to 044239. This is the same book that we've had some excerpts of admitted already. And the English translation is at 044212 to 044216-ET. Thank you. And if we could turn in the Albanian to 044213, and actually also in the English 044213, please. And if we could zoom in on the Albanian on the bottom two photos, please, and the caption. Thank you. And if we can scroll down on the English, I believe the caption is translated. Yes, thank you. Now, witness, this is from your other book that we've already discussed yesterday, I believe, yes. And on your right, you see the Albanian version with the images and the caption, and on the left, it's an English translation. And could you confirm whether the image on the bottom at the right also depicts the location where the unit of Ferris Guri was situated?
Po.
Yes, it does.
And do you recognize anyone in either of these two photos, the one at the bottom left or the one at the bottom on the right?
Në fotografinë të
On the picture on the left hand side, I see myself and two of my brothers and two other co-fighters.
And were your brothers and the co-fighters also part of Brigade 162?
po.
Yes.
The location in which you and your brothers and the co-fighters are depicted in this image inside the building depicted in the image just on the right-hand side of it?
Po, mrenda.
Yes, inside.
And on the image in which you've identified yourself and others, we see a timestamp, 2/4/1999. If you remember, would that be the 2nd of April 99 or the 4th of February 99? What would make more sense?
Këto qysh
As it is represented here, it should be 2nd of April 99. But again, as I said earlier, these photographs were extracted from the recording.
I understand. And Your Honor, I seek to admit these two pages. They could be added to the exhibit from this book that's already been admitted. I believe that's 1014.
Any objection? I'm
No
sorry.
objection.
No objection being heard, those two pages will be admitted.
Your Honors, for the record, pages 044213 in Albanian and its corresponding English translation, extracted from the book with ERN 043900 to 044239, will be added to the exhibit P01014.
Thank you, Your Honor and Court Officer. And Court Officer, we could please go to another exhibit. And this is SPOE 000-91385 to 000-91408 RED. It's important that the RED version is displayed, please. And if we could please first turn to the page ending 91402. Thank you. And if we could scroll down just a little to see the heading, I think it says, yes, it says picture 15. Yes, perfect. Thank you. And witness, do you recognize the location in this image on your screen now?
Duket që është objekt.
It looks like the building at the Hassani house, but I'm not certain because this has changed, seems to have changed.
So it seems like the one where Ferris Guri's unit was located, is that correct?
Duket ashtu.
That's how it looks. However, it's not a complete picture, and I'm not able to ascertain this with 100% certainty.
So let's please turn to the next page, which is 91403, picture 16. And witness, same question. Do you recognize the location on your screen now?
Again, it's not a full picture of the building, so I cannot be certain that it is that building.
And just for clarity, that building you're talking about, the one in which Ferris Guri's unit was located, right?
Correct.
We won't seek to admit these two pages, and I just want to note that an unredacted version has been admitted, and that's P372. But I wanted to note for the record that the pages as shown to this witness, 4576, contain redactions to the captions in that admitted document. Court officer, we can take this document down. And witness, my next question is whether you know someone called Yanus Shordani.
Janus.
Janus.
Po.
Yes.
Was he a member of the KLA?
Po ka qenë nga.
Yes, he was starting from March 99.
And what was his role in the KLA from March 99?
Nuk më kujtohet.
I don't remember because he received his tasks from the brigade commander Chamil Ilazi.
So am I understanding correctly that he was in Brigade 162?
Po ka qenë brigad.
Yes, he was in Brigade 162, but I don't remember his tasks because he received them from the brigade commander Chamil Ilazi.
And witness, actually, Your Honor, I see the time and we need to stop for a break at 10 o'clock, I believe.
We will take a short break. Madam Usher, please escort the witness from the room. We will take the promised 10-minute break at this time. We're adjourned.
All rise. All rise.
Be seated. Madam Usher, please bring the witness back in. All right, Mr. Prosecutor, you may continue.
Thank you, Your Honor. Witness, did Brigade 162 have a military police unit?
Paul,
Yes.
And who was in charge of that unit?
for Jessica,
The person in charge of that unit was Jabir Eleze.
And when did Jabir Elezi become in charge of the military police unit in Brigade 162?
nunca disse, nunca
I don't know, because that was not part and parcel of my responsibilities. It was instead the responsibility of the brigade commander.
And did Jabir Elezi report to the brigade commander?
till kommandant i brigaden.
To the brigade commander.
Now, could you remind us when when Chamil Elazi became the brigade commander?
Jamil Ilyazi kamordet
Jamil Elazi became the brigade commander when Agim Bayrami fell in August, on the 10th of August 1998. So he continued commanding the brigade from that time onwards.
And do you recall whether Jabir Elezi was in charge of the military police unit while Agim Bayrami was still alive and commanding the brigade?
nu kom kujto.
I don't remember. I have no knowledge about that period of time. It was just the beginning for me.
And when you took over as acting commander of Brigade 162 in May of 1999, was Jabir Elezi still in charge of the military police unit in Brigade 162?
På.
Yes.
And do you recall roughly how long he had already been in charge of the unit before he took command of before he took acting command of the brigade?
Den här presidenten Putin.
Can you please repeat the question once again?
So you became acting commander in May of 1999. How many months before that, if you remember, was Jabir Elezi already the commander of the military police unit?
Nunca di.
I don't know. We didn't have the time to deal with the times during the war period. I have never asked him, and I have no information. I don't know that.
Meet Jabir Elezi yourself in 98 or 99?
In 1999, after the 15th of May, yes, I did meet him.
Did you ever meet him before the 15th of May 1999?
You.
No.
Court officer, I'd like to show a page from 043900 to 044239. That's the Albanian. And in English, it's 044174 to 044186 ET. And again, these are, I'm going to show another page from the book, which parts of which have already been admitted as 1014. And the pages I'd like to turn to are in both pages 044183, please. Thank you, Court Officer. And witness, once again, you see 2 pages on your screen. As you saw, they are from your book, the Flake Pashawar book. And on the right is a document is a page in Albanian, handwritten. And on the left is a translation that we have created in English. And we see that it refers to the operational structure of the military police, and that it's authored by Shapir Ilezi, commander of the military police. And I ask you if you could kindly have a look at the information in this document and let us know if, to your knowledge, the information is correct.
The way on how well it is written by hand shows that this is a document that is written after the war. This is a document that I didn't possess during the war, but that's something that I have written after the war. So you can see the kind of writing that is used in this document is beautifully written. During the war times, we didn't have the time to write this well and to regulate things and to reflect things in the way that you can see from this document.
And am I understanding correctly that you're saying you yourself wrote this document after the war?
No, I have not written this document myself because this is not my handwriting. I can't write this well.
And what makes you say that it was written after the war?
During the war, I have not seen this document. That's the reason why I'm telling you this.
Could you tell us when you first obtained this document?
After the war, but I can't tell you exactly when, at what time. It was after the war, after I had already started to write the book.
Where did you obtain the document from?
I obtained the document from Jabir Eleze, my co-fighter.
And when you obtained it from Jabir Elezi, your co-fighter, did he tell you anything particular about it?
I don't remember. I don't know whether we have discussed about other things.
Now, this document refers to Jabir Elezi. It seems with a pseudonym or a nickname, Shari. Is that correct? Is that Jabir Elezi's nickname or pseudonym?
I don't remember, because during the war, I have never heard of the pseudonym. During the war, I knew him by his first name and last name, as he did know me.
And we see in this document towards the top part, under Jabir Elezi, we see Yunus Shordani, Assistant Commander Security. I asked you about Mr. Shordani before. Do you recall whether this was indeed his role within the brigade or the military police?
I don't know.
Now, at the bottom of the document, we read the following. We could scroll down so we can see the bottom part of both in English and Albanian, please. Thank you, Court Officer. So, witness, I'm just going to read, and you can follow from your screen or from the interpretation. On 9 April, at the place known as Proni Kachokit, Kachok Brook in Kachanik, the following fell heroically in action: Fadil Chaka, Nehat Chaka, Ilir Jarku, Mohammed Zeneli, and Farooq Dogani. Rustem Dema was wounded. Witness, do you recall, if that's correct, that on the 9th of April, those named persons fell in action and Rustem Dema was wounded?
Yes, it was on the 9th of April 1999 that there were very harsh fightings in Rakos and in the third neighborhood of Kachanik. And it was on that exact date that 28 martyrs were killed, as well as 32 citizens of Kachanik. So some of those people that fell during those fightings were the people whose names you just read.
And do you also recall that Rustem Dema was wounded in fighting on the 9th of April?
Yes.
And for clarity, this is also 9th of April 99, right?
Right. Yes, it's the 9th of April 1999 during the fightings.
If we look at the document towards the bottom right, where we have a list of 10 people in 4 Squadron or Squadron 4, we see a few names, some of which I've read out already. So we have, for example, Fadil Chaka, Rustem Dema, Nehat Chaka, Ilir Jarku, Mohammed Zeneli. And to your knowledge, witness, were these persons indeed in part of a squadron in the military police unit before they fell or were injured in April of 99?
Yes.
And if we look at the list for the first squadron, a bit further up and on the left, one of the names we see there is Nuhi Provolio. Do you recall that it is indeed correct, whether Nuhi Provolio was in the military police within Brigade 162?
I cannot remember everyone. However, this is a list that was written by someone that was in charge for the unit. I cannot tell you everything about every person in the list because that was not my responsibility.
And putting aside what's in the list for the moment, do you know who Nuhi Provolio is?
I know Nuhi Provolio because the municipality of Kachanik is a small one, and almost everybody knows everybody else there. I know him like every other citizen in Kachanik.
Whether Nuhi Provolio was a KLA member in 1998 or 1999?
Yes, he was.
And within which brigade or battalion?
I'm always talking about Brigade 162, Agim Bayrami, in Kachanik.
Whether he was in the military police unit of Brigade 162 or some other unit?
Based on this document, he was part of that. That's what we can see. However, I might be wrong because I don't know every soldier. I don't know every unit. It's not possible for me to do that.
At the bottom left of this document, we see a reference to Kula-e-Hassanit, Hassan's Tower. And that's the same location you mentioned earlier in the village of Bob, where Ferris Guri's unit was located. Is that correct?
Yes, that's correct. You should have into consideration the fact that this is a document that is beautifully handwritten It's embellished, but then in the end, there is no date, there is no signature. And this is something that you have to take into account, because I've repeated several times that these were things that were embellished, amplified, and this is a document that probably shouldn't serve that, shouldn't be considered very seriously in the context of this very important case.
What beautiful embellishments in this document you're referring to, please?
For example, it is very beautifully handwritten. So there is a ranking of the units according to the squadrons. There are 2 days, and then there is the Tower of Hassan at the end, but then there is no date. There is a reference to the commander, Jabir Elezi, at the end of this document, but there is no signature to this document. And these are factual things, and they tell of how valid this document is.
And we also see a reference at the bottom of the document to Sadiq Guri being killed in the village of Bichech on 25 May 1999. Do you recall whether that is correct, that that person died on that day in that village?
Yes, but it was not only Sadiq Guri that fell on the 25th of May 1999, because there was a very fierce fight going on in Kachanik, Gorge of Kachanik, Dubrav, other surrounding villages as well, and there were many martyrs that fell during that day. The Serb forces massacred the civil population, and about 13 citizens of this area were massacred by the Serb forces.
Point that seek to admit this page, both the Albanian and the English, and we propose that that would be added to the already admitted pages of P1014.
Anything?
No objection.
No objection being heard, the document will be admitted.
Your Honors, page with ERN 044183 in Albanian and its English translation, extracted from the book with ERN 043900 to 044239, will be added to the exhibit P01014. The classification is public, as the book was reclassified to public this morning.
Go ahead, Mr. Bach.
Thank you, Your Honor and Court Officer. And Court Officer, we could take this document down and call back up the other book, which is 036622 to 036837. And that's in English, and the Albanian version is 077039 077258, and pages from this have already been admitted as P1015. And if we could turn in the English on the left-hand side to page 036645, and in the Albanian on the right to page 077063, please. And I'll be reading in the English from the third paragraph on this page and from the Albanian from the first paragraph on the page.
At this point, Your Honor, we will object again to leading. The matter should be put to the witness under the principle of orality, what he knows about the topic. He should be asked viva voce. And again, I cite to the authority I cited yesterday from the ICTR, Karamera, that if there's something that the prosecutor needs to follow up with the book about the witness's recollection, then he can attempt to do that under the rules, but he can't lead the witness by asking him about events that he hasn't posed to him yet.
Overruled. Go ahead.
And witness, as I said, I'm going to be reading from the English version. You can listen to the interpretation in Albanian or follow from the Albanian page in front of you. And you state as following, quote, "At the order of KLA HQ, Shukri Buya returned to Kaçanik and announced the decision of HQ to appoint Agim Bayrami commander of the Kaçanik unit." And that's the end of the quote. And then there is a footnote number 21, which when we go to the bottom of the page, we see it referring to an interview with Major General Shukri Buya in Lipjan on 23rd May of 2007. And witness, my question is whether this means that Shukri Buya provided you with this information that I just read out in 2007.
Can you please repeat the question once again?
Certainly. So I read out an excerpt of your book, and then I also read out what you cite in the footnote, that being an interview with Shukri Buya in 2007. And my question is whether this means that Shukri Buya provided you with the information I read out in 2007.
Shukri Buya është
It is true that I have talked with Shukri Buya, but again, here there are too many things that have been amplified, that are embellished by me, and they were not things that were told to me by Shukri Buya. I don't have any documents where I'm based on.
Sentence again, and I would like you to pay particular attention, because after that I'm going to ask you to tell the judges specifically what you have embellished and amplified in it. The sentence reads, "At the order of KLA HQ, Shukri Buya returned to Kaçanik and announced the decision of HQ to appoint Agim Bayrami commander of the Kaçanik unit." That's the end of the quote. So as I said, witness, kindly explain to the judges what you embellished or added to that.
The first thing is that I have not seen any order of the general headquarters about this thing. Second, Shukri Buya did not tell me as it is written there, but he did instead tell me that he appointed Agim Bayrami as the commander of the Kaçanik unit. So these then are the things that I have embellished and have represented the way that I wanted them to be read.
And I'd like to turn to, I'll seek to admit these pages, which are 036645 in English and 077063 in the Albanian, and then I'll move on to another page.
We object for the fact that it's inadmissible under 1432C, inadmissible under 138. Thank you.
The document will be admitted.
Your Honors, page with ERN 077063, Albanian version, extracted from the book with ERN 077039 to 077258, and English version page with ERN 036645, extracted from the document with ERN 036622 to 036837, will be added to the exhibit P01015. Classification is public.
Thank you, Your Honor and Court Officer. And if we could kindly turn on the same document to, in the English on the left, page 036669, and in the Albanian, page 077088. And in the English, I'm going to start reading towards the middle to end of the page, and the same for the Albanian. It will spill over to the next page. Witness, this is again on your screen on the right in Albanian, on the left in English, pages from the book that we have just been discussing. And I'm going to read something that you wrote in here, and then I have some questions about it. Quote, the KLA HQ formulated a wider strategy for the liberation of Kosovo, Area 1, changed the name of the sub-area of operatives to reflect their changes as per Area 1, Kosovo, codename Kosovo, and put its liberation as a primary goal. The sub-areas became areas covering the same regions as before, and retained their existing structure. After the preparations of November 1998, and as laid out by the HQ Plan of Operations, the Neredim Area Command decided to form two brigades. Brigade 161 would operate in the Jezerts region, and Brigade 162 would operate in the Kaçanik region. After these preparations, the area commander sent invites to Shukri Buya, Chamel Ilazi, and Harish Kortai on November 27, 1998, asking them to travel from Kaçanik to the area's HQ in Molopolsk. They arrived at 2300 hours, and after a short break, met with the area commander. The meeting participants were Shukri Buya, Imri Ilazi, Chamel Ilazi, and Harish Kortai. Shukri Buya informed the participants that after the reorganization and restructuring of KLA, they needed to choose a name for the brigade. Immediately, Commander Chamel Ilazi proposed that the brigade be called after fallen commander Agim Bayrami. The operative sub-areas became areas, and the KLA units became brigades. The area commander proposed that Brigade 162 choose Chamel Ilazi as commander and Harish Kortai as vice commander. They were charged with choosing new members for their headquarters and proposed commanders for battalions, platoons, units, and squads. They also proposed the formation of a military police unit and reinforcing the logistics department. Ahmet Kaçiku became the commander of the 161st Brigade, and Nebi Musliu vice commander. The commander of the military police of the Arab Operative Nerdima became Isaac Musliu Churches. And that's the end of the quote, witness. And my question is whether the information that I just read out to you from your book is correct.
Objection leading violates the principle of orality.
Mr. Honor, I believe you have overruled this objection, and perhaps it could be stated as a standing objection so that we don't need to repeat it every time.
The objection is overruled. Go ahead.
Mr. President, if we could get clarification on Mr. Potch's point, otherwise I will continue to make my record unless we agree that it's a standing objection.
If you wish to make it a standing objection?
As long as that we agree that preserves our rights on appeal, I'm fine to do it that way as well.
Go ahead. That's fine.
Thank you.
So, witness, is the information from your book that I just read out to you correct?
No, this meeting never occurred. I personally was not present at such a meeting, and this shows at its best what I've repeated so many times now, that things have been embellished. I did not participate in that meeting. I don't know whether the other deputy commander took part, but in my book this is how it's represented, that we met, that we discussed, but in reality I personally did not participate in such a meeting.
You wrote and then published in your book that you attended the meeting in November 1998. That was a work of pure fiction.
It's not pure fiction, just an embellishment. I just presented things the way I would have liked them to have been at the time.
And witness, at least my understanding of an embellishment is something happened, but you add details to it. If you're going to say that this is an embellishment, could you explain what actually did happen? So let's take away what you embellished. What happened? What is relevant, or what happened in relation to this meeting in November 98, if anything?
More concretely, I did not participate in that meeting. I don't know whether the commander of the brigade participated in that meeting. That I don't know. As I said, I presented this event the way I would have liked it to have been.
I'm going to go back because it was a rather lengthy excerpt, and I'm going to break it down, and then I'm going to ask you more specific questions there. I'll start again from the top. The KLA HQ formulated a wider strategy for the liberation of Kosovo, Area 1, changed the name of Siberia of operatives to reflect their change as per Area 1, Kosovo, codename Kosovo, and put its liberation as the primary goal. Now, witness, from what I read, is that correct or incorrect?
This too was an aspiration, a wish, because all Albanian areas and parts were occupied for more than 100 years by Serbia, and our aspiration was to liberate Kosovo, and that's what we fought for.
Focusing specifically on the change of name from sub-areas to reflect their change per Area 1, are you saying that this did not happen, that Kosovo as a whole did not at some point become known as Area 1 within the KLA?
I did not say that it wasn't Kosovo. I said that our wish was to liberate all Albanian occupied areas. The reality was that we fought for the liberation of Kosovo.
But was Kosovo itself ever known, or was Kosovo itself ever known as Area 1 or Zone 1 or something 1 in the KLA?
I didn't know that, and I did not personally see any document in this respect.
And in the next sentence, you state, the sub-areas became areas covering the same regions as before and retained their existing structure. Is that correct, witness?
As I said, we started as a voluntary army with small units, sub-zones, later on zones. This is all I can say in this respect.
And witness, you're not answering the question. The question is whether what I read to you was correct. And you wrote, the sub-areas became areas covering the same regions as before and retained their existing structure. Is that correct or not correct?
I will repeat it again. What I've written here was a wish I had, not a reality. Had it been a reality, I would have to have documentation to support what is written here. And I did not have such documents regarding the zones that I've mentioned here.
So witness here, you talk about sub-areas becoming areas. Let's change that a little bit, and if we talk about sub-zones becoming zones, are you familiar with that ever happening in the KLA, or is that not something that happened to your knowledge?
Nuk më kujtohet sakt.
I don't remember precisely.
In your area, the Neradim subzone, was there a time when it became the Neradim operational zone instead of a subzone?
Po.
Yes.
When that change took place, did the area covered remain the same? So the Neradim zone covered the same area as the Neradim subzone had?
Kur ka ndodhur sakt, nuk e di.
I don't know when this occurred precisely, but it is true that it had the same area of responsibility.
Si në zonë,
Because the responsibility of 162 Brigade remained Kaçanik and its surrounding area, both when Nerodime was a sub-zone and later a zone. This was the area of responsibility of 162 Brigade Agim Bayrami.
Structure, to your knowledge, did much change when there was a change from subzone of the Neradim subzone to the Neradim operational zone? Was there much by way of structural change there?
nuk kam njohuri dhe se
I don't have knowledge about this because the zone was not my competence.
And you were in Brigade 162. In fact, you were the deputy commander and acting commander of Brigade 162. When there was this change from subzone to zone, did you feel that anything in your brigade changed structurally or not?
jo se
No, because it was not my responsibility. This was the responsibility of the brigade commander. I had other duties.
You were functioning in the Brigade 162, right? When you were deputy commander and commander. You were working as part of the brigade, correct?
sigurisht se punoja si
Of course, I worked as part of the brigade because I was deputy commander for combat operations on the front line. My duties were to prepare the units and the soldiers for combat on the battle lines. As far as combat and front lines are concerned, I am ready to answer to any question you pose, of course, to the extent of my knowledge.
The sentence that I read out to you earlier is the following. After the preparations of November 1998, and as laid out by the HQ Plan of Operations, the Nerodima Area Command decided to form 2 brigades. Could you tell the judges whether that is correct or not?
prape përsëres.
Again, I'm repeating, we
Correct or incorrect? You've explained, you've made that explanation enough times. Just answer his question.
Atëherë po ma cungoni drejt.
You are taking my right to say what I want to say and what I know. In relation to this is not true.
To answer his question.
Përgjigja ime është nuk është.
My answer is it is not correct.
I will read the same sentence again, and then I'm going to ask you to tell the judges what about it is not correct. The sentence is the following. After the preparations of November 1998, and as laid out by the HQ Plan of Operations, the Nerodima Area Command decided to form 2 brigades. Now, witness, please tell the judges what about that is not correct.
Nuk është e vërtetë se nuk ka
It is not correct because I did not see any plan of the general staff or the command of the operational zone because the brigade command or the zone staff were not my responsibilities. I was responsible for the combat operations on the combat lines. So I cannot give you any more precise answer.
You said just now that you didn't see any plan of the general staff. Did you hear or learn about such a plan from anyone or through any other means?
vetëm unë nuk jam këtu me
I'm not here to speak about things that I've heard. I'm here to speak about things that I've seen myself and about things where I personally was involved. I cannot give you answer to things that I've heard.
You're here to answer the questions that are put to you unless the judge doesn't allow those questions. So when I ask you a question such as, did you hear about this? It's your duty to answer it unless the judge tells you don't answer that question. So once again, witness, in your response a few moments ago, you said you did not see any plan by the general staff in relation to the information I read out. Could you please tell the judges whether you heard or learned about it some other way?
në kohën e luftës jo.
During the war, I didn't.
You learn or hear about it at any other time after the war?
Jo.
No.
And do you remember ever telling the prosecution that you got information about such a plan from Commander Chamililazi?
Për momentin nuk më kujtohet.
I cannot recall that for the moment.
The witness said he cannot recall this at the moment. I'd like to show an excerpt from his prior statement with your leave.
Go ahead.
Thank you, Your Honor. And court officer, that would be 074301-TR-ET part 4, and the same AT for the Albanian, please. And I'm going to start reading from page 6, line 13 in the English, and page 6, line 24 in the Albanian. Sorry, that would be page 6, I believe, line 9 in the Albanian. Witness, so as I mentioned, this is from your February 2020 SPO interview, and I'm going to read what's recorded here, and then I have some questions for you. So, question. And here, witness, before I start, I should say we're referring to your book. In fact, we're referring to the very same excerpt that we were just discussing. Question. At page 36669, you say that, quote, after the preparations of November 1998, and as laid out by the HQ Plan of Operations, the Neradim Area Command decided to form 2 brigades, end quote. What HQ Plan of Operations are you referring to? Answer. Because in the beginning, originally, it was the Kachanik unit that was operating. So after the transformation and the increase in numbers, it turned into Brigade 162. Question. Am I right in understanding that it changed from a unit to a brigade based on this HQ Plan of Operations that you refer to? Answer. Yes. Question. How did you become aware of an HQ Plan of Operations at the time? Answer. based on the information I got from the commander, Chamil Ilazi. Question. So am I understanding correctly that the General Staff prepared a plan of operations and communicated it to Chamil Ilazi or to someone who communicated it to him and then him to you? Answer, yes. Now, witness, do you dispute that these are the answers you provided during your February 2020 interview?
Apsolutnie kundërshtoj se
I absolutely dispute it. Even if I've given such an answer, I did not see any such order or plan from the General Staff to base my knowledge on such documents.
And so, witness, am I understanding correctly that you are now telling the judges, while you are under oath, that the information you provided that I read out to you was not correct, it was false?
nderuar prokuror, disa
Respected prosecutor, I don't want to hear the word lie. You are repeating that word every now and then. If you continue to use that word, I will stop my testimony regardless of the consequences, because I'm not bothered with the consequences. Please remove the word lie from your vocabulary. Even during the investigations you were using, whether it was a professor who lied or you who lied. So please do not use this word. I will stop my testimony. I am aware of the consequences. I know that you're authority that can take measures against me, but I will not tolerate to use this word anymore with reference to me or the professor or any citizen of the Republic of Kosovo for that matter.
Perhaps before the break, if I could turn to Your Honor to guide the witness into responding to my questions and doing so in a manner that's both truthful and responsive to the questions actually asked, please.
We'll do that right after the break. Madam Court Officer, please take the witness out of the courtroom. Do not speak to anybody about your testimony in this courtroom. We will take a half-hour break as scheduled. We're adjourned until 11:30.
All rise. All rise.
Please be seated. Madam Court Usher, you can bring the witness in. Witness. Witness, I want to be very clear with you. You are here today and yesterday and probably tomorrow to testify as a witness. Your obligation here is to answer questions that are put to you and to tell the truth. You have no other obligation. You don't get to decide what the question would be or what language is used. Whether you are considered to be a liar or somebody else is considered to be a liar is not up to the prosecution, it's not up to the defense, it's not up to you. It is totally up to this panel to decide if somebody is or is not lying. And you can rest assured that we will do that. We will carry out our duty and make that determination about your testimony or anybody else's testimony in this case. But you do not get to object to the questions that are asked to you. Your obligation is to answer them. Almost always it's a yes or a no or a correct or incorrect. Once in a while something else is needed and the lawyers will ask you then to explain. Do you understand all this? Yes or no?
It's hard.
Yes, it's clear.
That's your obligation, and if you don't follow your obligation, there could be consequences, and we don't want to go into that. But you are here for that sole purpose, to answer questions. You understood? Are you understanding me?
Yes, understood.
We would like to finish your testimony in a reasonable time, and making long statements that are evasive are not helping us get to the end of your testimony. Mr. Prosecutor, you may continue.
Thank you, Your Honor. And Court Officer, we could pull up the same pages from the prior statement we had before, which were 074301 TRET Part 4, also in Albanian, from the English at page 6, line 13, and from the Albanian also at page 6, towards the end of the page. Witness, just because we had a break, I'm going to read the exact same portion from your 2020 SPO interview again. And then once again, I'm going to ask you whether it's correct or not, because you did not provide me with an answer to that. Question. At page 36669, you say that after the preparations of November 1998, and as laid out by the HQ Plan of Operations, the Neurodim Area Command decided to form 2 brigades. What question? What HQ Plan of Operations are you referring to? Answer. Because in the beginning, originally, it was the Kachanik unit that was operating. So after the transformation and the increase in numbers, it turned into Brigade 162. Question. Am I right in understanding that it changed from a unit to a brigade on this HQ Plan of Operations that you refer to? Answer. Yes. How did you become aware of an HQ Plan of Operations at the time? Answer. Based on information I got from the commander, Chamil Elazi. Question. So am I understanding correctly that the General Staff prepared a plan of operations and communicated to Chamil Elazi or to someone who communicated it to him and then him to you? Answer. Yes. Now, witness, as I said, could you tell the judges whether your answers here were correct or not correct?
I said it before and I will repeat it again. I have never seen a plan from the General Headquarters. The unit of Kachanik was transformed into a brigade. That is correct, but I've never seen a plan from the General Staff.
Of you. Listen to the question again at the end and answer the question.
Your Honor, I'll read the excerpt again and ask the question again. Witness, I'm going to read this now, I believe, for the 3rd time. And I'm telling you now, my question after I'm done reading is whether the information provided is correct or not, so please bear that in mind. Question. At page 36669, you say that after the preparation of November 1998, and as laid out by the HQ Plan of Operations, the Neredim Area Command decided to form 2 brigades. What HQ Plan of Operations are you referring to? Answer. Because in the beginning, originally, it was the Kachanik unit that was operating. So after the transformation and the increase in numbers, it turned into Brigade 162. Question. Am I right in understanding that it changed from a unit to a brigade based on this HQ Plan of Operations that you refer to? Answer, yes. Question. How did you become aware of an HQ Plan of Operations at the time? Answer. Based on information I got from the commander, Chamililazi. Question. So am I understanding correctly that the General Staff prepared a plan of operations and communicated it to Chamililazi or to someone who communicated to him, and then him to you? Answer, yes. And that's the end of what I'm reading, witness, and my question once again is only whether that is information that you provided that is correct or not correct.
I don't remember.
And just to be clear, you don't remember if the information you provided in February 2020 is correct or not, or are you saying something else?
I don't remember because you're not allowing me to give explanations. You are restricting me to saying yes or no. If you want me to say yes or no, you can say whatever you want, because I cannot give you the answers you want from me. I can tell you what I know and what I don't know, what I've seen myself and what I've not seen.
You're here to answer the question. If the lawyer wants something else added as an explanation, he'll ask for it. And if he doesn't, perhaps the defense will. But it is your job to answer the question as asked. Is it correct or is it incorrect?
I cannot say it is correct or it is not correct because you are not allowing to give you are not allowing me to give clarifications.
It doesn't need a clarification, it just needs an answer.
Then it is not correct.
Go ahead, Mr. Potch.
Thank you, Your Honor. Witness, could you explain to the judges what about the excerpt I read to you is not correct, please?
When you refer to the operational plan of the General Staff, that is not correct, because I said before that I have never seen a plan of operations of the General Staff. I haven't seen it with my own eyes, and nor has it been communicated to me by the brigade commander.
So, witness, you just said that the plan by the General Staff was not communicated to you by the brigade commander, but as you see, or as you heard me read out to you from your prior statement, when I asked you question, so am I understanding correctly that the General Staff prepared a plan of operation and communicated it to Chamililazi or to someone who communicated to him and then him to you? Your answer was yes. Could you explain to the judges why in February of 2020 you answered yes? That is, that Chamililazi received the information about the General Staff plan and then communicated it to you, whereas now you're saying that that's not actually correct?
Probably it was an omission by myself back then, or probably it was a misunderstanding because of interpretation. But I stand to what I said before, that I have never seen a plan of operations of the General Staff.
And do you recall, witness, in your preparation session that you were provided opportunity to review your prior statements and then to provide any clarifications or corrections?
nuk e kam kuptuar drejt,
I haven't understood it correctly. The way I understood it is that if there was a misunderstanding or if there was a need for some technical improvement, I would have to intervene, but I did not understand it in the way that I would have to make more general changes to the testimony.
Your Honor, at this stage, I'd seek to admit the pages from the book that I read out to the witness, and those, just to refresh recollection, are pages from the English 36669 to 36670, and from the Albanian, page 077088 until the next page, page 9. And that is from, those would be being added to Exhibit P01015.
Mr. President, we'll note our objection to the admission of those portions of the book, first because they are not being tendered pursuant to Rule 143-2C. Therefore, anything that is inconsistent in the book with what the witness's oral evidence was cannot be used for the truth of the matter as asserted. And I just want to add our legal position on it. It would violate Article 21(4)(a) of the law, Article 6(1) of the European Convention, and the right to an adversarial proceeding. And therefore, we would argue that it's not admissible for the truth of the matters asserted in the book. Thank you.
And, Your Honours, may I make it clear, because I haven't done so on the record, that the standing objection and its elaboration are adopted by the Vasili defence throughout.
Thank you, Mr. Emerson.
And Your Honour, for the record, that applies to us too.
And the Krasniqi defence as well, Your Honours.
Thank you all.
Your Honour, just to respond briefly, we've heard nothing from counsel that should go against Your Honour's previous decisions on the matter, so the objection does not have any ground unless you're seeking reconsideration of your earlier decision. And these pages should be admitted.
Mr. President, if I may just respond, we're as you may have inferred, we're preserving our record on appeal, but we're more than happy to establish a procedure along the lines of what Mr. Potts proposed earlier, that with respect to admission of excerpts of this book, that the objection I just articulated and I articulated yesterday is a standing objection, and any non-objection going forward will not waive our right to appeal the issue to any future questions or portions of the book. Thank you.
Thank you. Mr. Potts, anything else? You're finished with your questioning?
No, nothing else on this matter. I was awaiting your ruling on the admission of the pages, Your Honour. I'm not finished with questioning.
Do you have any other pages that are going to come up?
As I go along, yes, there will be more pages. I'm just trying to keep everyone on track. So then would these pages be MFI'd, or we'll just hold on to them until the end, Your Honour?
We'll hold on to them till the end.
Thank you, Your Honour. And Court Officer, if we could please call up once again the book, which in English is 036622 to 036837, and in Albanian is 077039 to 077258, please. And in the English, I'd like to go to page 036767, and in Albanian 077187, and we're going to look at the document at the top of these pages. Thank you, Court Officer. Witness, once again, on your screen, on the left in English and on the right in Albanian, we have 2 pages from your book, The KLA War in Neridim Operational Area. And I'd like you to focus on the document at the top of the page, which the Court Officer is now zooming in on. So again, on the left, at least the title is in English, the document is the same. And on the right, it's in, the document is the same one, the heading is in Albanian. And we see, if we scroll down a little bit in the Albanian as well, please, Court Officer, just for the caption, thank you. We see that the caption is, from your book, Decree of KLA HQ to change sub-areas into area of operatives. And we can also see, hopefully, that the document is dated 19 November 1998 in Pristina, and that's at the top of the document itself. And witness, do you see that?
Yes, I do.
And do you also see towards the middle of the document the word vendim, which I'm told means decision?
Yes.
And we see a seal at the bottom of the document. Do you recognize that seal?
Yes, the seal, yes.
And what seal is that?
That's the seal with an eagle in the middle. It also contains the KLA, which is the Kosovo Liberation Army. That's the seal.
Where did you obtain this document?
I obtained this document after the war in the command of Unit 6 of the Kosovo Corps, Kosovo Protection Corps.
And witness, to your knowledge, is this document authentic?
I have said it during the questioning that during the wartime I did not admit this document. If I received this document during the wartime only with a signature, I would have not admitted it because there is no first name, last name of this document, and the signature is inadmissible to myself. But like I said, I have only seen this document after the war. I never saw this document during the war.
And you told us you obtained the document from the command of Unit 6 of the Kosovo Protection Corps. Do you have any reason to believe that the documents held by that unit or location were included false documents?
I have not conducted any detailed study about that.
Do you have any reason to believe that this document that you included in your book was false?
I have no reason to believe, but given that this document has no first name, no last name, but only a signature, to me this document is not very telling.
And witness, are you able to read the text in Albanian of the document on your screen or not?
Yes.
And can you tell us what it says in the main text, please?
Operational subzones of the Kosovo Liberation Army are proclaimed operational zones.
And are you able to read what it says above that, above Vendim, or is it not clear enough for you to read?
I can't clearly see it.
And court officer, let's please keep the version on the left-hand side on the screen, but on the right-hand side, could you instead kindly call up SPOE 00228818 to SPOE 00228818. Now, witness, do you see a new document has appeared on the right-hand side of your screen, but we've kept the document we're talking about on the left-hand side. Do you recognize this document on the right-hand side of your screen?
No, I don't recognize this because I have not seen this before and I can't read at the end on who issued this document. For as long as I don't know who has issued this document, I can't recognize it.
Okay, so witness, just to put things into perspective, the document on the left is the one we've been talking about from your book, and the one on the right is a new document. Will you agree with me that the documents appear to be similar? And court officer, we can perhaps scroll so we can also see the signature. Thank you. Yes.
It looks like they are the same.
And we see, for example, the word Vendom decision in both, right? And we can see it's legible, the text that you read out earlier about the announcement that the KLA operation subzones are declared operation zones, right?
Yes.
And similarly, the seal that we discussed earlier appears to be the same, right?
Yes, it looks like that.
Both documents are signed, both the one on the left and on the right. Do you happen to be able to recognize the name and the signature?
There is no name there about the signature. I don't recognize that signature.
And you see on the left that both documents refer to Pristina, 19 November 1998, right?
Right.
The top of the document above the word Vendom decision. And at this point, court officer, if we could kindly take down the document on the left, and instead of that one, call up the English translation of the item on the right, which is SPOE 00228818-ET.
Could you read that ERN number again, please?
Of course, SPOE 00228818 to SPOE 00228818-ET. Yes, I see it's on our screen now. And witness, just so that you understand what's going on, the same document in Albanian is on the right. I've just now called up an English translation of it. And earlier you told me that from the version in your book, you couldn't read the text above the word decision, so I'm going to read that to you now. And that says, the General Staff in the meeting held on 12 November 1998, based on their needs for reorganization, restructuring, and command establishment, issues as following, and then we have the word decision. Witness, my question is whether you ever heard from anyone in any way about this meeting of the General Staff on 12 November 1998, and that leading to the decision that we have before us.
During the war, I have never heard about this meeting.
Did you hear about it after the war?
While I was writing the book, when my collaborators provided some information, that information we reflected in the book.
Judges who, if anyone, provided you information concerning this General Staff meeting on the 12th of November 1998, please?
After I saw this document, that is 10 years after the war.
Please go on. What happened after you saw this document 10 years after the war? Witness, perhaps you haven't understood the question. I'll repeat my earlier question. Could you tell the judges who, if anyone, provided you information concerning this General Staff meeting on 12 November 1998?
Këtë informacion e kam
This information I saw in the documents of the command of Zone 6 after 10 years.
Witness, a few moments ago I asked you, did you hear about it after the war, the decision, the meeting of the General Staff in November 98? And your answer was, while I was writing the book, when my collaborators provided some information, that information reflected in the book. Can you clarify if the information you're talking about is the actual document you included, or did somebody tell you something about it or about the meeting in November?
jo askush nuk më ka thënë, po
No, nobody has told me about that, but I have seen it in this document.
Collaborators you're talking about when you answered my question.
po bashkëpunëtorët e për librin janë
The collaborators are the editors of the book, the professor, the chief editor, the photographer. Those are the people I mean.
Did the editors of the book give you this document or talk to you about this document or the November 1998 meeting? Could you clarify?
gjithë ky ka qenë ekipi që më ka ndihmuar.
This was the entire team that helped me to write the book.
My question is whether your team provided you with the document or any information about the document or the November 98 meeting referred to in it.
Dokumentin.
The document.
Who specifically provided you the document?
Nuk më kujtohet.
I don't remember it now.
Qenë shefi komandës.
Because I was responsible of the command of Zone 6. And I didn't have direct supervision.
Mr. President, there is an issue with regards to the two Albanian documents. I don't think it's appropriate to do it in front of the witness, but I do have an issue that's arisen about a comparison of the two documents. So I'll just note it for the record, and if you want to hear it, I can do it in front of the witness or outside the witness's presence. But
if it needs to be heard outside the witness presence, we'll have him.
I just don't want to be accused of leading the witness. So.
Okay.
Sorry, just Your Honor, if I may intervene. If it's perhaps relating to a comparison of the one document with the SPO number and the version in the book, I'm getting to perhaps something that you are asking about before I seek admission.
Go ahead,
Then
Mr. Pach.
I'll reserve my position. Thank you.
Go ahead. We can always break if you need to. Go ahead, Mr. Pach.
Thank you, Your Honor. Witness, just to be clear, earlier you said that the document that you put in your book, you got that from the Kosovo Protection Corps, is that right?
Në komandën e zonës 6.
From the command of Zone 6 of KPC, where I was a chief.
And court officer, could we keep the document on the right and call up the same page as before, which is page 036767 from 036622 036837? Thank you, court officer. So witness, once again, we have the version of the document from your book on the left and another version that I provided on the right. I think we've agreed that they are similar documents. Would you agree with me that one difference appears to be that in the version in your book, there is a handwritten annotation at the top towards the middle of the document?
Yes, there is.
And that reads to me 01/89, and then under that 81001. Do you have any information about what that refers to?
During my questioning, I told you that I don't know, and I still don't know.
Thank you. And Your Honor, we seek admission of the page from the book which contains this item, which is in Albanian in English 36767, and in Albanian 077187, and then also of the other version that we have shown to the witness, which is SPOE 00228818 to SPOE 00228818, and its English translation as well.
Your Honor, I will make the objection that we dispute that this is the same document, and I can articulate the reasons now or outside the witness's presence, however you wish to proceed.
Please take the witness out of the room.
Your Honor, before we do that, could I just be heard momentarily? I won't say anything that would influence the witnesses.
Just stay for a moment. Witness, you'll be excused for a few minutes. Go ahead, Mr. Pach. He wanted to explain something first.
Yes, Your Honor, I was just going to say that the fact that there may be difference between the version that the witness included in his book and this other version is not a bar to admissibility. So if that's the objection, I don't see the basis for that objection. And once again, that would be an issue that would go to the weight which is attributed towards the end of the trial on the balance of the evidence before the panel, and not with admissibility of either document.
Go ahead, Mr.
Well,
Misicic.
I just want to note, because it's being said that it's a different version of the same document, and we note that at least two additional differences other than the one that Mr. Pach highlighted, which is that in the upper left-hand corner there's a number. In the version on the right, it's clear to be /108. On the version on the left, it's illegible, but it would not appear to us to be similar to a 108. And then if you go to the bottom of the page, the seal, the stamp, the positioning of the stamp is slightly different. So the one on the right appears almost even with the first line there to the right, and the one on the left, the seal seems to be slightly higher. So we would not concede. We have no objection to the page on the left being moved in for its own value, whatever it is, but the assertion that these are two versions of the same document, we would dispute. Thank you.
We understand your dispute. Go ahead, Mr. Ellis.
Your Honor, we also object to the page on the right, the separate page being admitted into evidence. The witness has clearly not authenticated it. He hadn't seen it at the time. He said that, in his view, the absence of a first name, second name was telling. And in addition, we have our standing objection to the conduct of the search of Mr. Krasnici's house.
Go ahead, Mr. Pach.
Thank you, Your Honor. Just briefly, again, we haven't heard anything that would bar admission. If anything, they go to admissibility. We are not saying the documents are identical. Clearly, they are not. The witness provided information about where he obtained the document in his book. It is, on its face, very similar to the separate document we're seeking admission of. I could add another difference if counsel wanted me to, which is the location of the signature on both documents is slightly off. We're not saying they're identical. Clearly, we're not. But that's beside the point when it comes to the matter of admissibility. As to counsel for Mr. Krasnici's submissions, those objections have also been overruled in terms of the search and seizure. Consistent with your prior rulings, we could give the information on that should you require it.
P036767 and SPOE 00228818 to SPOE 00228818 are admitted. The objection does not affect admissibility as far as the court's concerned. It deals with matters that are unimportant to the issue at hand. Go ahead.
Your Honor, just a clarification. The English translation from the document 0366702 with the ERN, apologies, the English translation with ERN 036767 is the only document that is to be admitted, not the Albanian version from the book.
No, we'll do both the English and the Albanian corresponding page is 077187, please. And that's, of course, in addition to the SPO document.
So Albanian page with ERN 077187 and its English version with ERN 036767 will be added to the exhibit P01015. And another document with the ERN SPO E00228818 to SPO E00228818 and its English translation will be admitted as P01016.
Thank you. Go ahead, Mr. Potch. Oh, got to have a witness. Please call the witness.
And Your Honors, just for the record, the document that was admitted as P01016 is classified as confidential at the moment.
That could be changed to public because it is similar to the also now public version in the book.
There's no objection that will be reclassified as... Mr. Potch, you may proceed.
Thank you, Your Honor. And the court officer, in the page on the left, could we now scroll down to the bottom two images, please? And could we call up side by side with that for now the Albanian version from the book, which is 077039 077258, page, once again, 077187, which has just been admitted. — 77187, please. And witness, once again, pages, actually the same page we're looking at before from your book is on the left in English on your screen and on the right in Albanian. We're now focusing on the two documents or the two images at the bottom here. And we can see that your caption for these two images reads as follows: Orders of KLA HQ Chief Commander, signed by Colonel Bislim Zerapi. And could you kindly tell the judges where you obtained this document from, witness?
After the war, I obtained this document from the command of Zone 6 of KPC.
And witness, to clarify, when you say you obtained it from that command, is that the archive that they kept or something else?
In the command
of Zone 6, where part of the TMK documentation was to be found.
And thank you, witness. Are you able to read any part from these two images on your screen or not?
No, it's not clear.
Yes, thank you, Court Officer. On the image on the left-hand side, so the first of the two images at the bottom of the page, would you agree with me that we can see in the middle the word urgerse, and I apologize for my pronunciation, I'm told that means order. Do you see that word in capital letters?
Po.
Yes.
And do you also see that subsequently the paragraphs seem to be numbered, and I can see on the right-hand side of the image that it gets as far as paragraph 10. If we could zoom on the image, on the next image on the right-hand side, Court Officer, please. So yes, correct, on the Albanian, so there, and perhaps we can try to do that with the English for what it's worth. Witness, do you agree with me that the last paragraph over there appears to be numbered number 10?
Nuk po shihet mirë.
It's not visible.
Do you see perhaps an 8 and a 9 at the commencement of the paragraphs preceding that?
Yes, I do.
Por afërsisht jo qartë, nuk po shihet qartë.
But still, it is not clearly visible.
Yes, thank you. And could we, Court Officer, zoom in on the signature block, the seal and the written information? Thank you. And witness, as I asked you before, could you tell us whether you recognize the seal that is included here on this document?
Vula po shihet me shqip.
The seal is visible. It contains the eagle and the acronym of the Kosovo Liberation Army, UCK.
And do you see, like I do, the word Bislim Zerapi above the signature?
Po.
Yes.
Moving your Court Officer towards the left-hand side of the same image, if we can, so a little bit on the other side, opposite the seal, let's say. Correct there. And let's do the same in the Albanian, please. Yes, exactly. And witness, here at least I see initials or letters that are SV/VG. Do you know what that happens to refer to by any chance?
Nuk e di.
I don't know.
And shifting now instead to the other page at the top left-hand corner. So, yes, so the other page. The other image, I should say. Yes, that's good in the English. Thank you, Court Officer. If we can do the same for the Albanian. Thank you. And if we could just go up a little bit in the Albanian so we can see the top of the... Yes, thank you. And witness, here do you see towards the top middle of the page that we have what seem to be handwritten, what is that, 01/94 above 81001. Do you see that in both versions?
Po.
Yes, I do.
And beneath that to the right, do you see the words operational zone command typed out, and then a handwritten word right next to that? Do you see that?
Po.
Yes, I do.
Could you read the handwritten word for us, please?
Mu lexu nuk
It is not readable. I cannot read it. It's not clear.
Would you agree with me that the typewritten words say operational zone command, and then the handwritten word says Nerodimes?
ka mundësi edhe pse
It is possible, although the R resembles V and the D resembles T, so it's not clearly visible, but it could be what you just said.
And Court Officer, as we did before, could we kindly keep the version from the English book on our screens on the left and collapse side by side with it SPOE 00228807 to SPOE 00228808. And yes, we can leave that as it is there. And witness, focusing only on the two images on your screen, just for clarity, again, the image on the left is from your book, and the images from the right is not from your book, it is another document. Would you agree with me that these two documents appear to be similar?
To make a comparison, I'm not able because the one on the left is not legible, so I cannot give you a precise answer.
And court officer, could we zoom out as much as we can on only this first page on the left, and then similarly, so that we can see that whole first page as such? I mean the first image on the left, sorry for the, exactly. Yeah, so just to focus on that one, we can see its totality. Perfect, yes. And then can we do the same for the image on the right? Could we just zoom out so that we see the top and bottom of that page? Thank you, that's what I was asking for. And witness, would you agree with me that at least in terms of appearance, these two pages look similar?
I cannot agree because there are changes that make them different, and I wouldn't like to take that responsibility to confirm that they are identical documents, because from their appearance they don't look to be identical.
Witness, I agree with you, in fact, that they don't appear to be identical, but my actual question is whether to you they appear to be similar.
They could be similar, but their substance is not, so I cannot take that responsibility to confirm that these are same documents, because we are dealing with serious proceedings here.
Not, could you clarify for the judges what you're referring to?
Since I cannot read the one on the left and compare it to the one on the right, I cannot confirm 100% that these documents are the same or similar.
In the document on the right, please move to the second page, and in the document on the left, just focus in on that second page. Thank you, court officer. And witness, as the same question I was asking before, would you agree with me that these documents, these two pages of the documents on the left from your book and on the right, not from your book, appear to be similar?
All I can say, because of the same name, Bistim Zirabi, here and there, yes, but as for the text, I cannot confirm because it's not legible.
Try to see what could perhaps be legible. Earlier, you agreed with me that you could see in the document on your book on the left the paragraph numbers starting, for example, 8 and 9. And do you see that actually we can see on this page they start from number 6 to 10, both in the document on the left and also in the one on the right?
I cannot see number 10 anywhere on the document on the left.
To the left?
Numri 9 shumë i
Number 9 cannot be easily identified as 9.
And, Your Honor, we seek to admit these pages. Both the page from the book is actually already admitted because it contained the document shown before. So all I seek to admit now is this other version that's not provided by the witness, which is SPOE 00228807 to SPOE 00228808, and the English translation, which has ET at the end.
Your Honor, the objection is similar to the objection to the previous document, but with even more force here, because the witness has done nothing to authenticate the document on the right. Putting a document that the witness can't read before him and getting him to speculate it might be similar is in our submission a poor basis for admission.
If I may be heard. Just briefly, Your Honor, of course, we tried to elicit from the witness what he can see from his own eyes as well. The point here being that the witness provided evidence on the authenticity of the document on the left, which is included in his book, and in our submission, the document on the right is similar and obtained elsewhere. Of course, the witness can't speak to its content as such, but first of all, we could also make bar table submission, for example, about it. This is a clearly relevant document. And again, the submissions we heard from counsel are ones that would go to admissibility, not weight, all things considered in the end of the case.
Why do you seek to admit this document that obviously nobody can read?
So to clarify...
I mean, we can read the one that's on the right, but we can't compare it in any way.
Yes, Your Honor. Our submission is that based on its face reading, it is very clearly similar documents in terms of the numbering of paragraphs, how it is set out, and other words which are in fact identifiable. And the relevance there is that the witness has told you that he took from the Kosovo Protection Corps, whereas the one that we obtained from sources which I can provide information on there, but it was not from the Kosovo Protection Corps, is in our submission very clearly the same document, or very clearly a similar document, not with the annotations. So that is the relevance of the exercise and why we're seeking admission. If you wanted submissions as to the content...
What is its probative value?
Certainly, Your Honor. So the witness in the caption said it's an order of the KLA Chief Commander signed by Colonel Bislam Zerapi for the document in his book. Very clearly, that is the same that applies to the document, the SPOE document. It is dated 18 December 1998. It refers to the KLA General Staff, to the regulations. It contains an order, a very detailed order in relation to the zones, and it is signed by KLA SHP General Staff Chief Colonel Bislam Zerapi. So in line with other KLA documents we have sought admission of and have been admitted to the bar table, we suggest that this certainly meets that test.
May I just invite your honours to inquire, or at least in connection with the questions of probative value. Obviously, as Mr. Thaçi has pointed out in relation to the last document, and Mr. Patch rightly conceded, they're not the same physical document. The stamps are in different locations and so forth. So, given that this is purportedly put forward as an order rather than multiple orders, which of these does the prosecution say is the authentic version? There can't be more than one. One must be the original of an order and one must be a copy. Which is said to be the original?
And if I may just add our additional point, with respect to your question, Mr. President, on the probative value, we still are not clear as to what the probative value is of two similar or same versions of the same document being admitted into evidence.
Same.
Yes, Your Honor, briefly. I could make long submissions about this, but I won't. I'll keep it. I know I keep it brief. I assumed as much. But just to counsel for Mr. Veseli's question, we are not again. because in our submission this document would have clearly gone into a bar table for its obvious relevance to the case, is that the witness is able to add an extra layer of authentication to a similar document. So that is it.
The court will admit the document, but it has very hazy evidential value. The weight will have to be determined later on, and it's possible that it does not receive very much weight. But we will admit it. It is admissible for the purposes stated, given the defects that the comparison has. That's all. Go ahead. We can assign a number to it.
Your Honor's document with ERN SPOE 00228807 to SPOE 00228808, and its English translation will be admitted as Exhibit P01017.
Thank you.
Witness, to your knowledge, did members of the KLA general staff ever conduct a visit or were they present within Brigade 162 area responsibility?
I did not have knowledge about this visit.
You said this visit. What visit are you referring to?
About you.
About the question you asked.
Ask differently. Witness, could you tell the judges whether you ever heard any information whatsoever about members of the general staff being present in the area of responsibility of Brigade 162?
No come the Juarasti have.
I never heard about that.
Do you recall mentioning a visit of that nature in your SPO interview in February 2020?
Even if I have mentioned that, I don't think I have. But even if I have mentioned it, that must have been an omission on my part, because I didn't have any information of such a visit.
Okay, Your Honor, since the witness doesn't seem to recall making such an assertion, with your leave, I'd like to go to the prior statement, 074301 TRET Part 2, and that would be from page 18 in the English and in the Albanian translation. Please bear with me. And the Albanian translation would be from page 22.
Mr. President, just to clarify, is this for purpose of refreshing recollection?
It seems to be.
Your Honor, the witness said he doesn't remember providing such information.
I say that's
so
your purpose, though, is to refresh it. Yes.
Then I have no objection. Thank you.
I didn't have my mic on. Go ahead, Mr. Potch.
Thank you, Your Honor. I'm just waiting for the pages to come up on the screen.
Mr. Potch, I remind you that you are now at 4.5 hours, which is your time, the time set.
Yes, Your Honor. I believe I have 5 hours in total. I would hope to complete it in the next half hour. Because of how things are going, I may ask for indulgence for an extra amount of time, but I will cross that bridge when I come to it.
Our indulgence may not be granted, so go ahead and try to get it finished in the time period given.
No, certainly, Your Honor. And witness, this...
We did call it cost you 10 minutes for the break at 10 o'clock, so you have that much leeway.
Your Honor, at this point, I'll also say that the witness's cooperation and answering has also cost me a significant amount of time, which couldn't have been foreseen. And witness, once again, in the screen in front of you, we have your prior statement to the SPO in February 2020. and I'm going to read from it, and I'd like you to listen to what I'm reading, and then I have some questions. Question: what kind of visits would happen in the 162 Brigades area? Who would visit? I can't say that there were any visits as such, because we didn't have the luxury to make visits at the time. At the time, it was the Rambouillet conference happening, and the leadership were obliged to cross the border on foot through that area. Question: when you talk about the leadership, who exactly are you talking about here? Answer: it was the responsibility of the commander dealing with that, so I can't. Such a long time has passed from that time, so I can't say. But everybody knew who went through or what part of the delegation went through that area. Question: and who? Answer: and it was the responsibility of the brigade commander mainly to deal with that. At the time, I was just told to prepare a certain unit that would carry out this escorting duty, and I was not privy to other more detailed information. Question: but the leadership here, are we talking about the KLA's general staff or something else? Answer: it is publicly known who are members of the Rambouillet delegation. I can't mention names because I might have learned about this later on reading something, so I couldn't say that at the time I knew exactly who they were. I might have learned them afterwards. Now, witness, is the information you provided in the excerpt I read to you correct or not?
është I saktë.
It is very true that it was not my responsibility and that I had no knowledge about the movements in that time.
Part of what I read to you, you say at the time it was the Rambouillet conference happening and the leadership were obliged to cross the border on foot to that area. Is that also correct, that the leadership were obliged to cross the border in that area when the Rambouillet conference was happening?
Kjo ka mund me qenë një.
This could have been an assumption on my part because I didn't have this information at the time, but after the war we all learned who led the delegation to Rambouillet.
Since I don't think you're particularly answering the question, but I'll perhaps rephrase. Did you learn during the war or after that members of the KLA who attended the Rambouillet conference visited or passed through the area of responsibility of Brigade 162?
Sakt nuk e di.
I don't know that accurately.
Do you know anything at all about KLA members who went to Rambouillet passing through or visiting the area of responsibility of Brigade 162?
Sa I përket brigadës 106.
With regards to Brigade 162, I don't know that because that was the responsibility of Chamil Ilyasi, the commander of the brigades. Whereas when it comes to the delegation of Kosovo to Rambouillet, the entire whole world knows that the delegation was led by Hashim Thaçi.
And to your knowledge, did Hashim Thaçi ever visit or was ever present in the area of responsibility of Brigade 162?
I have said this back then, and I'm telling you right now as well. I have no knowledge whatsoever about such visits.
Court officer, if we could kindly call up the book, which is now partially, parts of it are in as 1015, so 036622 to 036837 in English, and in Albanian 077039 077258. And in the English, I would like to turn to page 036818. And in the Albanian, it's going to be page 077238. So in English, 036818. And in Albanian, 077238. And I'd like to focus on the image in the middle on the left, please. Witness, once again, these are pages from your book that we've been discussing at some length today. And in relation to the picture and the caption that the court officer is now zooming on the left in English and on the right in Albanian, I'll read the caption in English, and it says, "The house of Reshad Bunyaku, where the delegation of Kele HQ stayed during their visit of the 162nd Brigade Agim Bayrami in Bichech." Is that caption correct, witness?
This caption is correct. But this is how the photograph was being given to me by other people. At the time, I had no information, no knowledge whatsoever about this house.
Who is or are this other person or persons who gave you this image and that information that you included in the caption? Please tell the judges.
I don't know who gave this photograph over to me, and I told you earlier, this probably is not the case. This is probably not true, because I said it before that in the book we have embellished things. Probably no delegation was staying in this house. I don't know. I had no knowledge about this during the war, and I can't confirm that this is true.
To the judges, why or what exactly would be embellishing by putting an image on your book and describing it as a house in which a KLA HQ delegation stayed? What exactly would purpose would that serve?
The purpose was to give more value to the book. But given that personally I've not seen the delegation and I had no knowledge about the visit of the delegation during the war, I cannot confirm today that that is accurate information.
Professor, I'd like to turn in the same items on the left to page 36807 and on the right to 077227, please. Witness, do you recognize these images from your book?
Of course I do.
Do you recognize them? What do you know about them?
These photos have been received after the war.
And where did you receive them from?
We extracted them from the recordings that we had with the brigade.
And if we look at the caption to the photo on the top on the left, we see that it reads, Chief of KLA Political Department, Mr. Hashim Thaçi, during his visit at the HQ of 162nd Brigade, Agim Bayrami. Do you see that, witness?
I do.
Seeing that, would you like to clarify or correct the information you provided moments ago to the judges that you had never heard any information about Hashim Thaçi being in the area of responsibility of the 162nd Brigade?
Objection under Rule 143, Mr. President.
Overruled. Go ahead.
So, witness, do you need me to repeat the question?
Yes, can you please repeat the question once again?
In the caption that we're looking at on our screen still, corresponding to the image, it says Chief of KLA Political Department, Mr. Hashim Thaçi, during his visit at the HQ of 162nd Brigade, Agim Bayrami. And my question to you was whether you would like to correct or clarify what you told the judges moments ago, that you had no information about Hashim Thaçi ever being in the area of responsibility of Brigade 162.
Again, I do confirm that I have not had any knowledge that the delegation of the General Staff has visited the Brigade 162. These photos have been taken after the war, and I cannot testify to the fact that this photo has not been taken from a mountain somewhere in Kosovo. We might have as well taken an extract of that photo, and we might have as well wanted to add some value to that photo. Myself, I have not had any information, any knowledge about the visit. I have not met with them, and given that I have not seen them with my own eyes, I cannot confirm that this is true. Whereas with regards to the book, I mean, probably I'm becoming superfluous into repeating it several times. But once again, I wish to tell you that we have embellished things and we have added things and we have represented facts as we wanted them to be.
Witness, when you inserted these images in your book and when you included that caption, did you have any doubt that the information was incorrect, that you're ascribing the caption to that image?
I didn't dive into that back then. I didn't think of it back then.
And witness, you mentioned that you embellished parts of your book for your own reasons or for certain purposes. Could you explain to the judges what purpose it would serve to add a caption here saying that Hashim Thaçi, the chief of the KLA political department, was in a visit to Brigade 162?
The purpose was for the entire general opinion, the world, in particular the citizens of Kosovo, because they all know Hashim Thaçi as the founder of the state of Kosovo. And as somebody that led to the independence of Kosovo. And this is something that we added to add value to the book itself.
I seek to admit these pages from the book 036807 in English and 077227 in Albanian.
Yes, Mr. President. The witness, this was clearly an attempted impeachment of the witness through the book. First, the prosecutor did not seek leave under 143 to do so. The panel does not have discretion to allow him to unilaterally impeach his own witness, and for that proposition I cite the ICTY Appeals Chamber decision on appeals against decision on impeachment of a party's own witness, 1 February 2008 at paragraph 28. So it cannot be used as impeachment and is inadmissible because the terms of 143 were not complied with. In addition, under the panel's ruling, this is not considered a statement for purposes of 143(2)(c) and is inadmissible on that grounds. It cannot be used for the truth of the matter asserted under any other rule for the reasons I articulated earlier yesterday and earlier this morning, namely that it would violate Article 21(4)(a) of the law on specialist chambers and Article 6(1) and the right to an adversarial proceeding under the European Convention on Human Rights. Thank you.
I assume joinder by the rest of the defense?
Yes, Your Honor.
Yes, indeed, Your Honor.
All right. P 036807 to 077227 will be admitted.
Your Honor, is a document, Albanian version with ERN 077227, and its English translation with ERN 036807. Excerpts from the book 077039 to 077258 will be added to the exhibit P01015. And classification is public. Also, if I may just clarify the classification for the exhibit P01017, which is SPOE 00228807-08, and its English translation, it is marked as confidential.
It can be changed to public. Thank you.
Mr. President, I see from the transcript, and I'm sorry to rise, but I did not cite the case name of the ICTY Appeals Chamber decision. It is Prosecutor versus Popovich, 1 February 2008, decision on appeals against decision on impeachment of a party's own witness. Thank you.
Thank you.
Thank you, Your Honor. Court Officer, in the same book, could we please turn to, on the left in the English version, to page 036806, and in the Albanian version to page 077226. And I'd like to zoom in on the two images at the bottom of the page, please. Witness, once again, these are images from your own book that we've been discussing, and I'd like you to look in particular at these two images that the court officer is now zooming in on. The image on the right of your screen, so on the page that is the bottom right image, has the following caption: Chamelilazi, Vebi Koraci, Eyo Prunieva, Hairo Shkortaj, Musa Zenuni, and Azem Guri in the house of Ramadan Sallahu in Bichech on 3/11/1998. And witness, are the people mentioned in the caption those featured in the photograph?
Po.
Yes.
And I note that the English version refers to 3/11/1998, whereas the Albanian version, as we can see, refers to 11 March 1998. Could you clarify the correct date of that image, please?
Tu po shkruan 11 Mars.
What it reads is 11th of March 1998.
Your recollection, is that correct, that this image was indeed from the 11th of March 1998?
Sakt, nuk muj me...
I cannot confirm it 100%. However, after the battle in Ivai in March, we withdrew and we were located afterwards in this house. That is true.
And just to clarify, the battle in Ivai is the 8th of March 1999 battle, right?
Po.
Yes, on the 8th of March.
And did you go to Bichech immediately after the 8th of March of 1999?
Në mbrëmje
In the evening, late in the evening on the 8th of March, we withdrew. It was about one night that we were staying there, and after that we got back to the tower of Hassan, to Hassan's house, basically.
And so am I understanding you correctly that you yourself and some or all the persons in this image with you were in Ivaya until the 8th of March of 99, and then in Bichech for a short while before moving on?
Po.
Yes.
Periudha e shkurtër është vetëm
The short period is just one night and one day.
And witness, could you tell the judges whose responsibility it was to discipline soldiers in Brigade 162?
përgjegjësia e komandantit.
It was the responsibility of the commander of the brigade, Chamil Yazi.
During your time in Brigade 162, in the various capacities that you occupied in 98 or 99, did you ever hear about a soldier in that brigade being punished in any way for the way they treated anyone?
Asnjë rast nuk ka pas.
There has been no case of this nature because the soldiers of the KLA responded to the call for the war voluntarily, and there were no such cases.
Did you ever hear about a soldier in any other brigade or battalion within the Neradim operational zone ever being punished in any way for the way they treated anyone?
Nuk kam dëgjuar as.
No, I've never heard of anything like that.
About the military police earlier, and my question is whether you ever heard about any member of the military police at any level within the Neradim operational zone or brigade being punished in any way for the way they treated anyone.
Nuk kam dëgjuar asnjëherë.
I've never heard of such a thing.
I've asked you about punishment. I'm now going to ask you about investigation. Have you ever heard of any soldier, military police member at any level within the Neradim operational zone being investigated in relation to the way they treated anyone?
Nuk ka pas kësi raste.
There have been no such cases, none of them.
The court officer, on the document still on our screen, I'd please like to turn to page on the left 36740 and on the right 077160. And in Albanian, that is, yes, correct. If we can focus, please, on the two images at the bottom of the screen. And witness, again, we see documents reproduced in your book. Do you recognize, let me just wait for the court officer to move the English one up. Do you recognize these documents which are appearing on your screen, which are the two images at the bottom of the pages I refer to?
Po dokumentet
Yes, these were the documents of the police formations of the Serb occupationist forces.
And where did you obtain the documents from?
këto dokumente e ka.
I said it during the interview as well. These documents I received from the police station that was controlled by the Serb police forces and the Serb administration the day of the liberation of Kačanik.
And could you remind us what day that was that you received these documents?
Me 12 qershor.
On the 12th of June, 1998, that was the date. 1999.
Kaq se Kaçanikun e kemi.
Because Kačanik was liberated on the 11th of June, late in the evening, and it was in the early hours of morning of the 12th of June that we started with the controlling of the buildings and of the environment so that we could establish the conditions for the citizens of Kačanik to get back to their homes and so that they could not be put into difficult positions and fall into mines or into difficult situations that were imposed by the state apparatus of Serbia.
Do you remember, or can you see with your own eyes, that these documents contain the names of a number of Albanian persons?
ka edhe nacionalitet edhe shqiptar edhe
Yes, there are Albanians, but there are other citizens as well, citizens of other ethnicities. I cannot say anything about these documents because these are documents of the Serb authorities. Therefore, Belgrade would have given better answers to your questions because these are documents that are drafted by them, and I have no further knowledge about these documents.
That you yourself obtained these documents, right?
po I kam gjetë.
Yes, I found them on the 12th of June when I entered the police station, after the forces of state police apparatus withdrew. So this is where I found these documents.
And before you found these documents in the location you mentioned, did you have any information about Albanians being aligned or enrolled with the Serbian police in any type of unit?
Nuk kemi pas aq njohuri.
We didn't have that much information. We could not have that type of information because Serbia stopped the communication means, but also the TV channel that broadcasted in Albanian. Therefore, we had very limited, very few possibilities to have access to that type of information.
And court officer, I'd like to keep the document on the left on the screen, and on the right instead, please call up SPOE 0093211 to SPOE, sorry, to 000-93212. And witness, once again, on the left we have an image or images from your book, and on the right we have a document that's not from your book. Would you agree with me that the page on the right of your screen appears similar to the page, the first page on the image on the left of your screen, which is from your book?
Ashtu duket.
They seem similar. So the document of the Serbian apparatus, so that's the document we're talking about.
The document on the right, could we turn to the second page, 212, please? And witness, again, would you agree that this appears to be similar to the document on the left of your screen, the second page?
Yes. And it is signed by the chair of the municipality of Kaçanik. That is the chair or the president of the occupationist Serb forces.
Now, court officer, on the document on the left of our screen, I'd like to turn to page 36703, please. And on the right, I'd like to call up the Albanian version, which is 077039, 077258, page 077123. And Your Honor, I note the time. I need maybe 2 more minutes to finish this point, and then after the break, I would need a maximum of 15 minutes, which I think would still be within. Thank you, Your Honor. So I'll just finish this point in 5 minutes, and then we'll break. And thank you, court officer. So yes, so and then in the Albanian, it's 077123, please. I'm going to be reading an excerpt from this page, witness. You can follow my, you can follow the interpretation in Albanian, or you can follow on the page in Albanian on your screen. And just for context here, you're referring to the Kotlina massacre on the 24th of March, 1999, and you state as follows. It is worth mentioning here that several local Albanian policemen were part of this massacre, and all others in the commune of Kačanik, also included in the official list number 41 of 98 in Kačanik of 12/29/1998. They were led by the violent chieftain of the Kačanik commune, Ognjenović Radoslav. The official Serbian list includes, and then after saying that, witness, in your book you list a number of names, of which I will only read some. Agi Midrizi, brackets Lanisht, Rahim Elezi, brackets Djurjadel, Nezir Topayani, brackets Soponica, Riza Kiki, brackets Kaire, Seifullah Molaku, brackets Ivaya, Isa Kluta, brackets Ivaya, and Bashko Mloku, brackets Kotlina.
May I maybe...
Interpreter's note, we could not interpret the passage because the pace is too quick, and unfortunately we could not find the appropriate extract.
Excuse me, the latter point was my concern. The page in the English is not on the screen.
Yeah, I couldn't find it
No.
either. You're correct.
You know, at this point, perhaps it's easier if we do this exercise after the
We'll
break.
break for lunch and straighten this out during the lunch hour, and we will be back at 2:30. Witness, we will have lunch now, and you will be excused for an hour and a half. We'll be back at 2:30. Do not speak to anyone about your testimony outside this courtroom. You may go with the court usher to be escorted from the room.
That's short.
Clear.
Your mind, Mr.
Yeah,
Hermanson?
very small housekeeping matter, if I may. This afternoon's status conference has been listed at a time when I have an unavoidable conflict and have to be elsewhere, which is not a problem in itself, because obviously co-counsel will be here to deal with the procedural matters. I wonder if you might permit me just at the appropriate moment, either at 5 minutes to 4, or I can get 5 minutes afterwards, just to say just a couple of basic position points about our position on some of the key issues.
Of course.
Thank you
we
very
can do
much.
that. Remind me if I tend to forget.
Thank you.
All rise. All rise.
Be seated. Madam Court Usher, please bring in the witness. All right, witness, we are ready to proceed. The prosecution is still having some questions for you. Mr. Potts, you have the floor.
Thank you, Your Honor. And witness, just before the break, as you'll recall, we looked at 2 images in your book, which you captioned as a list of local Serbian police in Kačanik. And then I had proceeded to read a passage from your book, which now that we have had the break in between, I will go to again. So court officer, if we please could call up the same last two documents that we had on the screen, and those are 036622, exactly 036837, and we're going to start at page 036703, and to be more specific, I'm going to start from the last two lines on this page, from "It is worth mentioning," and then I'm going to go over into the next page, so that's for the English. And for the Albanian witness, you can hear the interpretation or you can follow on your screen. I'm going to start from the third line on the page, Vlente Čekat. Yeah, over there. So, and witness, once again, as I reminded you earlier, in this passage, you're referring to the Kotlina massacre on 24th of March, 1999. And you state as follows: "It is worth mentioning here that several local Albanian policemen were part of this massacre, and all others in the commune of Kaçanik, also included in the official list number," if we can move in the English, yep, number 41 of 98 in Kaçanik, 12/29/1998. They were led by the violent chieftain of the Kaçanik commune, Ognjenović Radoslav. The official Serbian list includes, and here, witness, as I said to you earlier, you have a list of names. I'm just going to refer to some of them. And we have Agi Medrizi, and in brackets Lanisht, Rahim Elezi, and in brackets Gjurgjedel, Nezir Topayani, and in brackets Soponica, Riza Kiki, and in brackets Gaire, Seyfullah Molako, and in brackets Ivaya, Iza Kluta, and in brackets Ivaya, and Bashkim Loku, and in brackets Kotlina. And after you list these and other persons, and I'm still here on I'm starting on the second paragraph of this page, you say the following sentence: "Whether consciously or subconsciously, these misguided souls served the enemy and harmed the Albanian people." Now, witness, my question to you is, what information did you have when you wrote this, that the people whose names I read out harmed the Albanian people?
U bazova në dokumentin.
I based myself on the document of the Serb forces and the occupying Serb apparatus who engaged these people within their structures. I am conscious that all military, police, paramilitary, and local forces organized by the Serbian authorities, the occupying state authorities, committed the Kotlina massacre in March 1999. 26 citizens were killed, of which 22 were massacred. They were captured alive by the Serb forces. They were beaten with various instruments until they lost consciousness, and then they were thrown in two wells just above the village of Kotlin in Shulak mountain. Most of them could have still been alive when they were thrown into these two wells. These wells were then blown up. This was confirmed by ICTY teams who carried out investigations afterwards, and who came to the conclusion that none of the bodies or remains of these victims was compact.
In your answer, in your first line, you said you based yourself on the document of the Serb forces and the occupying Serb apparatus. Are you here referring to the document we looked at before the break, or to some other document?
The document we saw just before the break.
In relation to the document before the break, you told us you obtained it in June of '99. Is that correct?
Po.
Yes.
Witness, could you
Me
explain
12 qershor natën.
On 12th of June 1999.
the judges how you obtained this document on the 12th of June '99, and you're now saying you used that as a basis for alleging that the people I read out to you were involved in the 24th March of '99 attack?
E përsëris prap dokument.
I will repeat. I obtained this document on the day of liberation on 12th of June 1999 in the police station in Kaçanik, where Serb forces operated during the war. And on that document, the names of the persons that you read out earlier were included. This indicates that all the forces of the Serbian forces, be they police, military, paramilitary, these people were included in those forces and took part in massacres carried out in Kaçanik and throughout Kosovo.
And do you recall that before the break, you also said that before you found the documents in June of '99, you didn't have information about Albanians being enrolled with the Serbian police. Do you remember stating that?
Po, derisa nuk e kam parë dokumentin.
Yes. Up until I saw the document, because I didn't know before that which forces took part in the fightings in Kaçanik.
So just to make sure I'm clear, the people you list here as having taken part in the March '99 fightings in Kaçanik, you're making that assertion in your book based on the document that we looked at that you found in June '99, right?
Në dokumentin e
And the document of the Serbian authorities.
The one we looked at before the break, right?
po.
Yes.
And witness, we have information that the people I mentioned, the names I read out to you, which I can repeat, were detained in locations including one or more of Bob, Ivaya, and Bicec around March of 1999. Do you know anything about that?
Unë nuk kam pas
I didn't have such information or any information with respect to this.
Did you ever hear anything about anyone being detained or having their liberty deprived in or around Bob, Ivaya, and Bicec in or around March '99?
asnjëherë nuk kam.
No, I never heard about it, and there were no such cases.
Very clear, witness, when you say you never heard about it. Am I understanding correctly that you didn't hear about it during the war and you didn't hear about it after the war?
As gjatë luftës, as
I didn't hear about it during the war, and I didn't hear about it after the war. Very simple, I was not interested in the Serbian forces.
And I'm not sure, witness, why you mentioned Serbian forces. What I'm asking is about information we have that the persons mentioned were detained by KLA members. I just want that to be clear. Do you understand that?
unë këtë informacion nuk e
I never heard this information, and I never possessed such information.
I wonder if I might raise the question of relevance, because the lists that are being shown to the witness are lists of Serbian combatants, part of the armed forces of Serbia, whether they happen to be of Albanian nationality is neither here nor there. They are combatants that Mr. Patch is asking about. So That's inevitably why you've just heard a lot of evidence about Serbian alleged massacres, which of course are also not directly relevant to the indictment. So I wondered if it might be the appropriate moment to take stock of where this is going.
Go ahead.
Your Honor, would you like me to respond or just to proceed? I can very quickly.
You may respond if you wish to.
Yes, Your Honor, the names that I read out are of relevance to hopefully everyone in the courtroom here, at least some of them would be, so with your leave I'll proceed with my questions of the witness.
You may proceed.
And witness, the names that I refer to, so very briefly, Agimidrizi, Rai Melezi, Nezir Topoyani, Riza Kiki, Saifullah Molaku, Isa Kluta, Bashkim Loku, are you saying that you never heard anything about them having been detained or their liberty being deprived even after the war? You never heard that?
I never heard that.
And witness, do you know anything about KLA members being tried in Kosovo after the war concerning allegations of crimes in locations including Baba Nevaja in February and March of 2003?
I have no knowledge about this. I didn't show any interest in proceedings carried out by UNMIK because I didn't trust them.
But you do know there were proceedings carried out by UNMIK in relation to KLA members in relation to crimes in Baba Nevaja, right?
I have no knowledge about this, and I simply didn't want to deal with such matters.
Witness, just to be clear, for at least for myself, are you saying you have no knowledge about this trial existing? You don't know whether this trial did or did not take place?
I don't have knowledge because these were of no interest to me. The staged proceedings by UNMIK were of no interest to me, and I simply didn't want to have anything to do with them.
You're referring to staged proceedings by UNMIK. What staged proceedings are you referring to there?
All those proceedings that you are mentioning here, I didn't want to have anything to do with them, and it was none of my responsibility.
Your Honor, at this stage I seek to admit the pages that I've referred to in the last couple of questions, including before the break. From the book, those are pages 036703 to 4 and 077123, as well as 036740 and in Albanian 077160. And to be clear, those are the pages which have the images that we discussed with the list of Serbian police, and then the passage that I read to the witness concerning the March 99 attack. And we also seek to tender into evidence the version that the witness agreed is similar to that in his book of what he has described as the local Serbian police, and that is SPOE 000-93211. And after that, I have a few questions, and then I can conclude my examination.
We don't object to any documents from the book being admitted into evidence. We do object to the portions that were read out, first for lack of probative value, lack of relevance. This is apparently what his opinions were in 2012 when he wrote the book. The witness has said he had no knowledge of these things during the actual indictment period. So first on relevance and probative value. Second, for the reasons I've articulated already this morning several times on Rule 143 being unavailable to the prosecution for various reasons, including that leave was not sought. Thank you.
Your Honor, I just rise to make one short point concerning consistency of evidential rulings and procedural Justice in relation to the use of documentation. Like Mr. Macetis, I would take no objection to any image shown to a witness and put to them and questioned, so that it can be properly contextualised in analysing the witness's evidence. But it has been the practice of the tribunal, of the panel, up until relatively recently, that when a witness is cross-examined on a document that is not admitted in evidence, the witness is testimony, and the part of the document that is read onto the record has been treated as sufficient, and when the defence have sought to tender documents in that way, we've been told that we should rely on the transcript, because the passages that Mr. Patch wants in and wants the witness's comments on have been read into the transcript, in some cases 3 times. So it's difficult to see why there should be a different rule than that which has hitherto been applied for the admission of the documents themselves. It may not be a great deal of prejudice, because the question of the evidence is the transcript. But it does seem to me that, with respect, we need to have this one sort, set the same rule in all respects, applied with some consistency.
Thank you. Your statement is noted. Mr. Patch, could we go through those numbers a little slower and one at a time, and stop after each one, and we'll deal with it.
Of course, Your Honor. So I'll start with pages 036703 to 036704. That's in English. And the Albanian is page 077123.
Any objection? Well, you've made your statement about that. That will be admitted. Go ahead with the number. Madam Court Officer, you may go ahead with the number.
Your Honors, pages ERN 077123 in Albanian, and its English translation with ERN 036703 to 036704 will be added to the exhibit P01015, and the classification is public.
Thank you.
And the next page is from the same, or the next page for the same item is in the English 036740, and in the Albanian 077160.
Which exhibit is that?
So, Your Honor, that is referring to the pages from the witness's book, which contain the 2 images of the list that he has testified about.
Right. 036740 and 077160 are admitted and will be assigned a prosecution exhibit number.
Your Honors, page with ERN 077160 in Albanian and 036740 in English will be added to the exhibit P01015.
Thank you.
And the last tender that I had, at least for now, are SPOE 000-93211 to 000-93212, and the English version with -et at the end. And just to refresh memory, that is the version of the images which Your Honor just admitted from the book, but it's from a separate document, and which the witness agreed is at least similar to the one in his book.
That document will be admitted as well.
Your Honors, document with ERN SPOE 000-93211 to SPOE 000-93212, and its English translation will be admitted as exhibit P01018, which is currently classified as confidential.
It can be reclassified as public, thank you.
Reclassified as public.
And witness, I have only very few questions left for you, Your Honor. It should be under 5 minutes. Witness, earlier we saw you in an image with Eoprunieva in your book, if you recall that. And my question was whether you could confirm that Eoprunieva was in Brigade 162.
Did you understand the question?
Nuk e kam qartë pyetjen dhe
No, the question is not clear to me. I don't know which photograph you're referring to.
More simple, was Aeroprinieva part of Brigade 162?
fotografi nuk pesha.
I cannot see the photograph.
There is no
Ignore-
question, there is no photograph, it is just a question. Listen to the question and answer.
I nderuar më herët më
Your Honor, the prosecutor mentioned the photograph that was used earlier.
Question to make it simpler. Repeat the question, Mr. Pach. Listen to the question.
Witness, was Aeroprinieva a member of Brigade 162?
po.
Yes.
Recall what role he played in that brigade?
Nuk më kujtohet.
I do not recall. It wasn't my responsibility. It was the responsibility of the brigade commander, Chamili Lazi.
And do you know Buyar Tafili?
E njoh si qytet.
I know him as a citizen of Kachanik, not more than that.
Do you know whether he was a KLA member?
Me siguri ka qenë, po
He probably was, but during the war, I didn't have the opportunity to see him with my own eyes.
Do you recall providing information in the RSPO interview that he was in the unit of Shabir Elezi?
ka mundësi që e ka.
It is possible I said that, but as I said, I personally didn't see him during the war.
Section, though, is that correct, that Buyar Tafili was in the unit of Shabir Elezi?
Në bazë të këtij dokumenti
Based on the document, yes, but personally I didn't see him during the war.
And was Enver Ajami a member of Brigade 162?
po ka qenë.
Yes, he was.
No further questions, Your Honor.
Before you start, Mr. Misitich, just to add some clarity to our previous rulings on these portions of the book that have been shown to witness 4576, the panel finds that the portions of the book shown are not statements within the definition of that notion applicable under the rules, as they are not taken in the context of a criminal investigation or proceedings. This definition has been consistently applied by this panel, as well as by other chambers of that jurisdiction and other jurisdictions from which our rules are inspired. The admission of the portions of the book are therefore regulated by Rule 138, Paragraph 1, as exhibits offered by the SPO. The panel is satisfied that the documents are relevant, prima facie authentic, and have clear probative value. Considering that the defense will have a full and fair opportunity to cross-examine the author of the book, the panel is also satisfied that the probative value of those documents are not outweighed by any prejudicial effect. The other submissions raised by the defense pertain not to the admissibility but to the use that the panel can make these portions once admitted. The panel will simply indicate that the suggestion that the panel would be limited in the use that the panel can make of these portions, in particular, defense's suggestion that the panel could not rely on them for the truth of its content finds no support in the rules, nor has the panel found any authority applicable before it that would support such a position. In particular, the oral order from the Caramera case, which counsel of Mr. Thaçi relied upon as authority for its proposition at page 80 of 20th of February 2024, does not provide authority for the position taken for two reasons. First, it pertains not to the admission of an exhibit, but to the admission and use of a prior inconsistent statement. Secondly, the ICTR limited the admission of prior inconsistent statements to issues of credibility of the witness, but not the truth of their content. Such an evidential regime is different and inconsistent with the one applicable before the KSC, where Rule 143.2c specifically provides for such a possibility. And that is in connection with the decision on Nsinga Yuma. Motion to admit documents as exhibits at paragraphs 6 to 7 on February 26, 2007. The panel is therefore satisfied that the portions of the book shown to and discussed with 40576 could therefore be relied upon for both the truth of their content and to assess the credibility of the witness and the reliability of his evidence in court. Now you may cross-examine, Mr. Misitich.
Your Honor, if I might, just before cross-examination starts, I have two brief matters related to the evidence. So first, I just wanted to know that as far as I have kept track, we have the admission status of 2 pages from the book, which is still pending with Your Honors. I just want to flag that. And those are pages 036669 to 036670 in English. And in Albanian, those were 077088 to 077089. And Your Honors postponed the decision on that, so I just want to mention that now. And then I just have one other tender to make.
Your Honours, just on that point. Sorry, Your Honour, I was just checking 36669. I recall being read partially. I'm sorry, I've got my page numbers wrong. I'll sit down.
That's all right. 03669 to 036670 are admitted. Now, Mr. Oh, and what are the two, those are the 2 pages. What's your second item?
So those are the 2 pages in English, and in Albanian, the translation of those pages are 077088 to 077089. And I can...
Number assigned to him, please.
Your Honors, Albanian pages with ERN 077088 to 077089, and their English translation with ERN 036669 to 036670 will be added to the exhibit P01015.
Thank you.
And then, Your Honor, our last tender in relation to this witness, at least for now, is that under Rule 1432C, we seek to tender the portions of his prior statement, that is 074301, that we have used with him. Certainly, Your Honor. So I was saying that under Rule 1432C, we seek to tender the portions of the witness's prior statement, which prior statement starts with the ERN 074301. And we are only, in the circumstances, seeking to admit under this rule the portions actually put to the witness during direct examination, and we can provide those portions via email or as Your Honor deems best later on. And just in case necessary, we cite as authority for such a procedure, amongst other decisions of this panel, decision F01903 of the 3rd of November 2023.
Record from the defense on this? Objection? Oh, okay. Well, why? We'll have you submit the documents, and we can rule on this later.
I do have the objection, and again, it's the same objection. I cited the Popovich case. They didn't seek leave, and they needed to seek leave under the rules if they were going to pursue under that rule, and they're precluded from now tendering it under Rule 143.2c, having not sought leave. And I specifically clarified that point for a reason, that he was seeking to refresh the witness's recollection and not to impeach the witness, which Mr. Potch confirmed. So that's the basis of my objection.
If I may just clarify something, at one point at least when I confirmed that I was seeking to refresh recollection, yes, I was seeking to refresh recollection, But based on the answers of the witnesses, what arose is that he has provided a prior inconsistent statement, which is now the reason why I'm seeking to tender only the prior inconsistent statement excerpts that I have read to the witness.
Understood.
May I just reply briefly?
Yeah.
Sorry. This is precisely the scenario that the Popovich Appeals Chamber had to deal with. I do believe that the drafters of the rule specifically incorporated the Popovich ruling to say that you have to seek leave for the reasons articulated in that appeals chamber decision. And regardless of what the prosecutor thought was taking place, you can't unilaterally, no party can unilaterally begin to impeach their own witness without leave of the tribunal, or of the trial panel. Thank you.
Thank you. You may now cross-examine the witness.
Your Honour, before Mr. Misicic starts, I apologise for taking a moment. I noticed that Mr. Patch used the form of words, our last tender for now. It'd be useful to know before we start cross-examination if the prosecution is intending to tender anything else with regard to this witness. The moment for that to happen, of course, being before we start cross.
Yes, I don't know what he means by that, but
I can clarify, it's just because I don't have a crystal ball, I don't know what's going to happen next, and sometimes we tender items, for example, in redirect examination, which we have not come to. So to be clear, those are our tenders as relates to what happened during the direct examination.
understood. Go ahead, Mr. Misicic. Last time you have to stand up on there, on this one.
Thank you, Mr. President. I do need to, because I believe, at least I'm inferring that the panel issued a ruling before I started my cross-examination for a reason, to put me on notice for cross-examination, and I do need to briefly just put my position on the record, which is this cross-examination will address the prosecution's case as it was put to this witness and as the witness answered. We therefore will address the witness's viva voce testimony and would be prepared for any testimony admitted under Rule 143(2)(c) as prior and consistent statements. With respect to what the trial panel may infer later on its own, will not be the subject of cross-examination because obviously the accused has a right to notice and does not have to speculate on what the panel may do with a particular piece of evidence. So this cross-examination is geared towards addressing the prosecution's case. I think we can argue it later about other legal issues I've raised, but in terms of the panel's ability to use for the truth matters that are inconsistent with the prosecution's case, we also rely on the European Convention, Article 6.1, and specifically cite Skondrianos versus Greece for the position at paragraph 28 to 31, Skondrianos. And with that, I will proceed with cross-examination.
Go ahead.
Yes, Your Honor, simply to say that we disagree with what counsel has just said, and we would invite the panel to remind counsel that if he has questions to put to this witness as they are relevant, they should be put now without any caveats as to what the panel will do later. The time to ask questions and to obtain information from this witness and items he may have information about is now.
Thank you for your comments. Go ahead.
Thank you, Mr. President. Witness, good afternoon. I am Luka Misicic, counsel for Mr. Thaçi, and I have some questions for you for the rest of today and into tomorrow. So let me begin with just a few questions about your background. It's correct that you served in the Yugoslav Army from 1986 to 1991. Is that right?
Four.
Okay.
Yes, it is.
From September of 1999 to January of 2009, you had the rank of Colonel in Zone 6 Command of the TMK. Is that correct?
Four.
Yes.
And you have worked in the Ministry of Defense. Is that right?
Four.
Yes.
Currently in the Department of Planning and Evaluation of the Ministry of Defense.
Po aktualisht kryket.
Yes, currently I'm still with this department.
And have you continuously been at the Ministry of Defense from 2009 until the present?
Prej vitit 2009.
From 2009 to date, I am working at that department.
Is it correct that you obtained your position through a public procurement process?
Këtë pozitë e kam marrë
I obtained this position through an open competitive procedure. I applied for the vacancy and I met all the criteria, therefore I was appointed in that position.
Your superiors are not political appointees, but rather members of the civil administration?
e saktë.
That's correct.
Let's ask some background about your political affiliations. You told the SPO that before joining the KLA in 1998, you had been an LDK member since 1991. Was that accurate?
E saktë.
Yes.
Is it true that you supported Ibrahim Rugova not only in the period prior to the war in 1998, but also after 1998?
E vërtet.
That's true.
Did you ever experience any negative reaction from anyone in the KLA to your support of Ibrahim Rugova?
Asnjëherë.
Never.
Would you say there was regular cooperation and coordination among LDK representatives and KLA members in the Ferizaj area?
Gjithherë ka qenë asnjë problem.
Always, all the time. There was no problem whatsoever in this direction.
Do you know who Fazil Hetemi is?
Fazlihet jemi. Jo, nuk e njoh.
No, I don't.
Salihu.
Adem Saliu
Adem Salihu lives in the same village as myself. So his village is actually next door to where I live.
Cooperate with Adem Salihu during the conflict?
nuk kam pas rast.
No, I have not cooperated with him. There was no occasion for me to do that because I was with Brigade 162 in the area of Kachanik. Therefore, there was no possibility for me to meet him.
Did you have courier communication with the LDK in Uroshevats during the conflict?
Jo.
No, never.
Is it true that you only ceased your membership in the LDK when you joined the Kosovo Protection Forces?
Po.
Yes. Yes. Because there was no time for me to deal with politics, and that's when I decided to dedicate my time to the Kosovo Protection Force.
Allowed to have a political affiliation while you were in the Kosovo Protection Corps?
Nuk ka qenë në
It was not prohibited by special laws, but it was not favorable for us to deal with politics while we were working for the Kosovo Protection Corps.
Okay. When did you enter politics after 2008?
Paraversisht 2000
Approximately in 2015. I can't tell you exactly, but that was around that time.
Something which is DHT 03714 to DHT 03716 at DHT 03715 to 16. we could actually scroll down a little bit, please. Actually, could we go back to the previous page, just to, so the witness is oriented? And scroll down a bit, please. Witness, do you recognize this Facebook page?
Po e imja ka qenë
Yes, this used to be my Facebook page when I was running for an MP in the Assembly of the Republic of Kosovo.
We now turn to the next page, please. And if we scroll to the bottom, please. If we keep going to, is that, yeah, that's the bottom, okay. So there's a section here that says experience in politics, Democratic Party of Kosovo, January 2009 to December 2015. Democratic Party of Kosovo is the PDK, correct?
po.
Yes,
President of the PDK sub-branch in Elazığ from June of 2012, is that correct?
Sakt.
correct.
PDK branch in Kaçanik, June 2012?
Sakt.
Correct.
And if we turn to the next page, please. Point 3, if it's legible. Well, it's not legible here, but point 3 said Assembly Delegate in PDK in June 2012. Was that accurate?
Dymije.
20?
Sakt.
Correct.
Can we go to the very bottom of the document, please? Okay. Yeah, you can see it roughly. Assembly Delegate in PDK in June 2012. And you only joined the AAK later, correct?
Më vonë.
Later.
I see. Like your Facebook page says, don't do that you joined in January of 2016. Would that be accurate? If we turn the page, please.
Sakt. Sakt.
Correct.
So my first question to you is, you were asked in your SPO interview by Mr. Potch at part 1, beginning at page 13, you were asked, did you then become involved in politics, meaning after January of 2009? And you responded that you joined the AAK, which is Mr. Haradinaj's party, correct?
Po.
Yes.
Having been in Mr. Thaçi's PDK party for approximately 5 years, 6 years. Is that correct?
Ka mundësi që ka qenë
That could have been an omission of myself, but my curriculum reflects everything in details.
When you published your book in 2012, you were a active member of Mr. Thaçi's party. Is that correct?
vërtet.
That's correct.
Political positions within Mr. Thaçi's party, is that fair?
Qëllimi im ishte që të
My goal was to take positions in the party, within the party.
Kaçanik, would you agree with me, is a PDK political stronghold? Would that be fair?
pajtona.
That's fair.
Now, witness, speaking about this book, you say you spent 7 to 8 years preparing the book, correct?
Parafërsisht kështu.
Yes, more or less.
And in preparing the book, you relied on various sources, is that true?
Po.
Yes.
Access to documents in archives, correct?
Yes.
Today that many of the documents that are in your book you had never seen during your time in the KLA. Was that accurate?
Exato.
That's accurate.
For example, you were asked during your interview with the SPO about a document allegedly issued by the General Staff, but you had not seen any documents from the General Staff during the war. Is that correct?
Në kohën e luftës
During the war, personally, I have not seen any documents.
Ability to confirm the authenticity of any such documents from the General Staff other than perhaps what you say you retrieved from documents in the late 2000s. Is that correct?
Exato.
That's correct. I can't confirm things that I haven't seen because, like I said, I haven't seen them during the war.
You were shown today documents purported to have been authored by Bislam Zarapi, and you said you never saw those documents during the war. Was that accurate?
Exato.
That's accurate.
Personal knowledge of the authenticity of any such documents, do you?
Your Honor, could counsel clarify any such documents? It's a very broad assertion.
Let me ask it very broadly. Any documents, did you ever see during the war any document purported to have been authored by Bislam Zarapi?
Nuk e kam parë.
No, I have not seen.
Documents that are in your book and purport to be authored by Bislam Zarapi, you have no personal knowledge of their authenticity, correct?
Nuk kam djeni.
I have no knowledge.
When you took documents out of the archive, did you do any independent research or verification as to the origins and authenticity of those documents?
Unë kisha me thonë jo prej
I would say that I received the documents not from the archive, but from the administration of the command of Zone 6, but I haven't dealt with any analysis or special research related to these documents.
Attempted, for example, to interview any of the purported authors of these documents to see if they claimed that the documents were actually prepared during the war. Is that accurate?
ashtu.
Yes.
Now, witness, you yourself have now testified in court on questions from the prosecutor about documents purporting to appoint you as commander in May, and you say, and the documents have your signature, so you're in the document purporting to appoint yourself. Do you recall those questions from the prosecutor?
Objection, Your Honor. Misstates the evidence. I don't recall the witness saying he was appointing himself.
He didn't say that, but the document says that.
Overruled. You may ask the question. You may answer the question.
Let me remind you, it was the document written in hand that says, pursuant to an order from Agim Cheku, and then you're appointed and you sign. And so that's why I say you're signing your own appointment order. Do you recall that?
Yes, that is something that I have written myself. I embellished it, I wrote it, I drafted it as I wished. However, I haven't received any special order by Agim Cheku. After the falling of Chamil Ilyazi, that was the time that I wanted to continue with carrying out that position.
If you embellished your own documents, how do you know that other people didn't embellish their own documents and they wound up in the archive?
Objection, Your Honor, calls for speculation.
These are documents in his book, Judge.
No, that was I'm sustaining that objection. That was very speculative on his part, on your question for him.
Well, the documents you publish in your book, how do you know that they weren't also embellished by other people?
Nuk kam ndonjë informatë.
I don't know. I don't have any information about that. I don't know.
Possible that the documents published in your book are also embellishments by other people?
Ka mundësi.
It is possible, but I don't know.
You have no idea how these documents wound up in the archives that you looked at.
Sakt.
Correct.
How KLA documents were collected after the war and archived? For example, your documents, if you had any documents during the war, what was the process by which, did somebody come by and say you have to turn over all your documents, or was it just freely anybody could give whatever they wanted?
Nuk e di sakt për
I don't know exactly because that was not part of my responsibilities. I was not in charge of archiving the documents of the KLA.
Well, did you have any documents that you had created during the war that you still had in your possession immediately after the war?
unë personalisht nuk kam
Personally, I haven't had any documents, any orders, or any plans. Whatever I had are there in the book.
I'm not being clear here, but I want to make sure that I understand you correctly. During the war, from June 1998 until June 1999, did you receive any documents as the deputy commander, or did you issue any documents as the deputy commander? Or the acting commander in May of 1999?
unë si zëvendës kom
As a deputy commander, I have not received any document, and I have not issued any document either. That was not part of my responsibility because that was the responsibility of the commander, not of the deputy commander.
Commander have issued some written document, even one, in the year that you were, roughly the year that you were the deputy commander? To you, I mean.
nuk kum kujtohet kjo.
I don't remember this because the circumstances of the war were such that we could not prepare draft documents and issue them.
If I understand you correctly, you had no documents to turn over to an archive after the conflict, is that correct?
Sakt.
That's correct.
Example, and let me ask it a different way, you became the acting commander in May. Did you ever see, for example, Chamilalazi's documents as his successor?
Edhe një herë pyetje.
Can you please repeat the question once again?
Rephrase. You succeeded Chamilalazi as the commander of the 162nd Brigade, correct? You succeeded him as acting commander, I mean. Correct?
Yes.
Acting commander, when the conflict ended, did you have responsibility for Chamilalazi's archive of documents as his successor?
Nuk
I found no document by the commander Jamil Ilyazi. It was only after the war that I saw the document that was issued. I saw that in the command of Zone 6.
Another question. How about Agim Bayrami? Did you find any documents as the third in line? You were the commander who succeeded Chamilalazi, who has succeeded Agim Bayrami. Did you find any documents of Agim Bayrami's?
Nuk kam gjetë për shkak
No, I found no document because at the time when Agim Bayram was a commander, it was the beginning of the war, and I found no documents issued by him. The place where Agim Bayrami fell in Kachanik, the house was burned down, and even if there were documents back then, I'm sure that they would have been burned down. That was on the 10th of August, 1998.
So if there are documents in the archive of the 162nd Brigade, how did they, based on the fact that you were the last commander during the conflict, how did they wind up in the KLA archive? What was the process?
nuk kam njohuri.
I have no knowledge about this because on the 12th of June, I handed over my responsibilities as the commander of the battalion, and I have no idea how they went about handing over the documentation, if there was any.
Question. Do you have any knowledge, either from the war or your efforts to write a book after the war, of how the archive collected documents from the war?
Një pjesë e dokumentacionit
A part of the documentation of the KLA was kept in the commands of the Defense Corps of Kosovo. And that's all I know. I don't know more than that.
You're referring to the period after the conflict, right? You're referring to the KPC or TMK.
mbas konfliktit, mbas luftës.
Yes, after the war, after September 1999, that's the period of time that I'm referring to.
How did KLA documents, do you have any knowledge of how KLA documents wound up in the archives of the TMK?
Nuk kam njohuri.
I have no knowledge about this because on the 12th of June I handed over my post. I have no accurate knowledge on how this process was carried out.
We seem to be getting the same answer over and over again.
I know. I just wanted to ask one more question.
Go
on this.
ahead.
Is there a person that you know of at the TMK archive who would know how documents were received? And I mean, not today, but someone in the 2000s who would have knowledge of, was there an organized means of collecting documents, or was just anybody who said they were in the KLA allowed to show up at the archive and turn over documents?
Nuk kam njohuri që
I have no knowledge that there was an organized process in place to archive documents.
Thank you. You say that you relied on books written by other KLA members when preparing your book, correct?
ka raste që jam mbështetur.
There are occasions that I have relied on other books. There are occasions that I've relied on mass media channels, on ceremonies and things of this kind.
Mass media, and I did want to ask you a question in response to an answer you gave a little earlier this afternoon, and for the parties it's page 97, actually beginning at page 96 going to page 97. In response to the prosecutor, you mentioned, you brought up on your own that the ICTY had conducted investigations and made conclusions with respect to the Kotlina massacre, and you even mentioned the ICTY's conclusions on the state of the bodies that were recovered from that massacre. Do you recall those answers?
Ka qenë një masakër që
Like I said before, it was a massacre where 27 citizens of Kotlina were killed, of whom 22 were massacred. They were captured alive by the Serbs. They were badly bitten, and then they were thrown in the well alive. And this is the reason why the ICT teams, they came up with the conclusions that you just referred above.
The ICTY concluded.
Based on the information from the media and during the reburial process, which I attended myself.
You were following ICTY conclusions based on things you read in the media, is that correct?
Yes.
Buya's testimony at the ICTY when it was broadcast on television in Kosovo.
Yes, I did, but a long time has passed since. But I did follow his testimony.
Follow.
I don't remember exactly.
Watched just a few minutes. Can you give us an estimate of how much you watched?
I couldn't follow all of it, but what I was most interested in, that part I followed. I followed the part on the Rechak massacre, on Kotlina massacre.
Ask you a few questions about your references to Shukri Buya in your book. And if we could turn to 036622 to 036837 in the English, and 077039 to 077258 in the Albanian. And the specific page I'm interested in is 036644 in the English and 077061 in the Albanian. And if we could go to the footnotes, please. So at footnote 17 in your book here, you cite to a manuscript by General Mayor Shukri Buya, dated May 23, 2007, entitled Remembering the Dawn of Freedom. Do you see that?
Yes, I do.
That manuscript by Shukri Buya when you wrote your book?
No, I didn't have a copy of this manuscript. It was simply a conversation with Shukri Buya, and then I embellished it in the book and rearranged it and presented it the way I saw it fit. But it was based on the conversation I had with him.
Ask a few more questions based on that answer. When you say you embellished it, you have a specific title of a manuscript here, right? Remembering the Dawn of Freedom. Is there such a manuscript? Did Shukri Buya publish a manuscript, to your knowledge, with that title?
No, I personally don't have knowledge about this manuscript.
Evidence is this footnote is, to use your words, an embellishment to the extent that you invented a manuscript and attributed it to Shukri Buya?
This was just a conversation I had with Shukri Buya.
what I need to know, are you telling us now that you're citing to a document with a specific title and a specific date that never actually existed? Is that your testimony?
Është saktë.
This is correct.
To the next reference here, and this is at page 036645, which is the next page in both the English and the Albanian. It's footnote 21. Now here, you actually cite to an interview with Major General Shukri Buya. You see that? And it's the same date as the manuscript you cited to on the prior page. So my question to you now, in light of your answers here, is why would you need to invent a footnote referencing a fictional or a non-existent manuscript when you were obviously capable of saying that other portions were attributed to an interview on the same day as the transcript, as the manuscript, excuse me?
Thjesht ka qenë një
Well, it's just a technical omission on my part, or incidental omission, and instead of mentioning the interview, I referred to the manuscript. It's an omission on my part.
And what I was going to ask you in my cross-examination is why there's a manuscript and an interview with the same date. And is it now your testimony that because there was no manuscript at all?
s'ka pasur, vetëm ka qenë
There wasn't any. It was just an interview, a conversation with Shukri Buya, and this was an omission on my part, the manuscript, that is.
Biography of the book, and this is at page 036827 in English and 077248 in Albanian. And if we scroll down to section C, Section C, you purport to put in a bibliography a list of the interviews and memoirs that you used to prepare the book. And if we look at page 831 in the English and 252 in the Albanian, at entries 78 and 79, your bibliography, where you're purporting to identify actual interviews that you had and manuscripts, the only things you list twice are the manuscript with no reference to any interview with Shukri Buya. Now, if you actually interviewed Shukri Buya on the same date as the manuscript, why doesn't your bibliography include a reference to any such interview?
E thash edhe më herët.
I already said it before, it's an omission on my part. A technical omission, I would say. But it's mine. It was purely a conversation or an interview with Shukri Buya.
Is it possible that, in fact, what you relied on was a manuscript with Shukri Buya that Shukri Buya had written and not an interview? And that's why it's not reflected in the bibliography.
Jo, nuk ka mundësi që kam pas.
No, it's not possible that I had his manuscript.
By the time you met with or discussed this or whatever happened on the 23rd of May 2007 with Shukri Buya, it was already 4 years after his ICTY testimony. Are you, or sorry, 3 years after his ICTY testimony. Are you aware of that?
Nuk Nuk e kom
Well, I did not dwell on this aspect.
You've already stated that the book was prepared and published at a time that you were attempting to obtain positions in the PDK. Is that correct?
po.
Yes,
Be a leader of the PDK in Kachanik, which is a stronghold of the PDK, correct?
Ky ka qenë qëllimi im.
this was my goal.
You've said this several times about embellishments and, but is it accurate that the book was written as a way to appeal to the PDK electorate?
Me një farë forme po.
In a certain form, yes.
Well, let me ask just a few quick questions. At the time the book was published, Mr. Thaçi was the prime minister, not only the leader of the PDK, correct?
Po.
Yes,
This is to Hashim Thaçi in your book, correct?
Po.
yes,
So you were not present at any meetings with Mr. Thaçi during the conflict, correct?
Ashtu është.
correct.
Mr. Thaçi or heard from him during the conflict? Is that correct?
Excuse me, we're having a problem with Judge Bartas.
Gjatë
During
Can you hear me now, Judge Barta?
Yes, thank you. We can hear you.
Okay. Let me repeat my question, witness. You never saw Mr. Thaçi or heard from him during the conflict, is that correct?
e kam thënë disa herë dhe
I've said it before, I will repeat it again. During the war, I never met him and I never communicated with him.
Mr. President, Mr. Emerson has asked for some time at the end. I don't know if...
Let's go until about 10 seconds.
10 till. Okay, thank you. Your reference to, in the book, to an order from Mr. Thaçi to start expanding military activities, you have no personal knowledge of any such order, is that correct?
ashtu është.
Correct.
Member of the KLA in March of 1998, is that correct?
Nuk kam qenë.
I wasn't.
There are numerous pictures taken from videos of Mr. Thaçi in your book, and some of them were shown to you earlier today. Do you recall those pictures?
Po, mas
Yes, after the war.
Is it fair to say that the only pictures where the face is quite visible are the two showing Hashim Thaçi?
Sorry, Your Honor, I don't understand the question. I'm not sure what is being sought by the witness. Perhaps it can be clarified.
In terms of the only identifiable persons in the pictures shown in the book are Hashim Thaçi. I can move on, that's fine. Well, rather than going through the book, I'll just move on, that's fine. Was there a political reason why you decided to include pictures of Hashim Thaçi in your book?
pikërisht e arsyeja politike
It was precisely this political reason to make the book more readable, knowing that Hashim Thaçi was a leader.
I'm being sabotaged.
You are being sabotaged.
Yes.
Mr. Micetic, while you are being sabotaged, you gave us a reference to the Skondrianos case. Would you be so good as to check the date of the decision and the paragraph? The transcript might have gotten the wrong paragraph reference. It doesn't need to be now.
Okay, thank you.
Do we have transcript? No.
We won't have a transcript of Mr. Emerson.
Mr. Emerson, do you see need to have a transcript for the comments you make?
Absolutely not, no.
Okay.
But
We may terminate now because we're having a transcript problem, and we can give you the floor.
Absolutely.
Okay. Is that all right with you, Mr. Micetic?
Of course.
All right.
thank you very much.
Well, is somebody working on it? Okay. We're told we can't proceed without a transcript, so we just step aside for a minute, relax. We'll take that up in a little bit. You can escort the witness from the room, Madam Usher. Witness, we'll see you tomorrow morning at 9 o'clock. Do not.
Okay.
Okay. Just relax for a moment. We'll take a short break while they restart the system. We're adjourned.
All rise.
Be seated, please. Before we give you the floor, Mr. Emerson, I just want to make one brief statement about what we're going to do, and that is I'd like to have us each concentrate on what your team can do. In other words, I don't really need to know, Mr. Emerson, I'm just using you as an example, what you think the prosecution ought to do. I want to know what you can do. I want to know what the Thaçi team can do. We'll come to this, but I just want to start off with the right idea that we need to hear from you about your ideas. Go ahead, you have the floor.
Sorry, Your Honor, just very briefly before that, Mr. Potch was going to put a short request on the record just before the status conference when the transcript went out. We can do that now. It's just an unopposed word extension request.
Go ahead.
It's for a Rule 155 motion. We will request 2,000 words because of the number of witnesses covered. The witnesses have already been shared with the defense, and we understand there's no opposition. Thank you.
No opposition?
Our position was we have no objection, provided that there's a reciprocal extension if needed for the response.
That goes without saying. It's granted. Go ahead.
Your Honor, very briefly, first of all, thank you for giving me just a moment to address the court before I have to depart. And obviously, my co-counsel, Mrs. Kerry Rowe and Ms. Annie O'Reilly, will deal with the agenda items as they arise. I wanted, if I may, just to say two brief words at the outset about the attenuation, if you like, the balance between expedition and transparency, both issues that that the panel has raised for this afternoon, and one small question on the timetable, just as general overview points. But first of all, my client has asked me to say that he wouldn't want the proceedings or the panel to sacrifice a full examination of all the evidence as it pertains to his personal involvement for issues of expediency or timetable. He's very keen that everything that can be said about what he did and did not do be publicly ventilated and available to the Kosovo public, upon whose behalf the tribunal was established.
And I think we all would agree on that general concept. So go ahead.
And so that having been said, we of course all support all efforts at greater openness and transparency, and we recognise that the process hasn't been ideal in a number of respects and hasn't been as fast in terms of de-redacting transcripts as it should be to enable the public to keep up, and anything that can be proposed to achieve that, we would certainly support to achieve a greater communication publicly. As far as the proposed timetable is concerned, we are entirely happy with the timetable as it is proposed, and by that I mean the schedule till the end of the year. We would struggle, if I'm honest, to do it any greater sitting times because of the degree of catch-up that is being played for two reasons. One, of course, is the fact that we started the trial with a very heavy deluge of very late disclosure, which we therefore had to schedule throughout the trial to consideration of material witness by witness. That has always been a problem all the way through, and that's, in a sense, why we have some breaks built in. The second point, of course, is that both Mr. Thaçi and Mr. Vasili have lost key members of their teams in the past couple of months. I'll leave Mr. Setic, obviously, to address the particular situations of Mr. Thaçi, but with the loss of our co-counsel, Mr. Strong, we also lost a lot of accumulated knowledge because he'd been working on the case for a great deal of time. So we would find it very difficult to sit any more frequently or any longer than the proposal that the panel has circulated in light of the practice that we've adopted. It looks to me to be a consistent, almost identically consistent practice to the ideal practice that we'd started from the beginning. And we would urge you, therefore, as much as possible to maintain that. And then the last thing I just wanted to say is we've discussed the question of time limits, of course, before. Obviously, if there are time limits, then all participants to the proceedings would need to consider time limits. It wouldn't, unless there's been evidence on the statistics of a particular problem arising from one section of the court, it would seem to us that if that is the way forward, then two things we would ask on behalf of any order that's made as far as the defence is concerned, and that is that it's a fallback time limit in the sense that that's the default position. But if there are particular witnesses for whom we can anticipate we will need considerable longer period of time, then we can, of course, with reasons, I would hope, make an application or request to the court for an extension of that. Obviously, we also entirely understand the need for revised time estimates, but in terms of ensuring that, and this is, if you like, the other side of the coin, that the prosecution has as much information as possible as to how long a witness is going to actually take. And certainly, it is difficult to predict those estimates. So we have an estimate for this witness which is down as 2 hours, but having seen the way that the testimony has been handled so far, we don't need to cross-examine, or at least unless anything further emerges that might change that position. So I think improvements, if we can, on a rolling basis of time estimates for cross-examination are also extremely helpful. We're keen to abide by anything that the court considers the right balance to achieve expedition and to ensure that the trial maintains its impetus. But as I said at the outset, subject to the necessity to ensure that Mr. Vasili has all of the evidence pertaining to him as far as he's concerned, and of course others will have their own position, fully ventilated, because he doesn't, having come this far, he wants the whole story fully out in the public domain, so that the Kosovo public can judge what he did and did not do during the course of the Liberation War in 1998 and 1999. So those are the submissions I wanted to make.
Thank you very much, Mr. Emerson, for your contribution, and we understand you have to leave, and it's perfectly all right. I will say, when it comes to the days that we sit, we somewhat agree with what you're saying, but we lose an awful lot of days to, our plan was to do 4 days in a stretch each week in the 3 weeks we sit. But we continually lose days for court maintenance, and that is a hindrance. It really bothers. And we constantly are questioning each other about, is there a better way to do that? That's one of the things we will discuss, and you won't be here when we discuss it, but we will discuss it, and you'll get the message sooner or later, and we'll try to come up with some sort of reasonable solution. Working with CMU, I mean, they have certain obligations to take care of this multi-million-dollar operation here so that it all works and so they live up to their contracts and all that. So. So let me just ask, are there any comments from the SBO? Is that appropriate as you see it?
Certainly, Your Honor, we can go straight to the schedule now. We received the calendar, and the discussion on the sitting schedule and available courtroom time is very important to us. We would welcome a regular schedule of 3-week blocks with 1 week off. The calendar now seems to be working on a model that's close. It's 3 weeks on, 1 week off, 3 weeks on, 2 weeks off, as I understand it. And so it's certainly getting in that direction. If there's any flexibility to sit additional weeks, which doesn't seem to be a dramatic increase, but it would be an important one, we would certainly welcome that, because the shorter breaks do facilitate greater continuity in scheduling and would increase available courtroom time. As for Fridays, in particular, we understand if they can't be generally incorporated into the schedule, which would be our preference, it would still be helpful if it was possible that Fridays could be reserved days on certain days, possibly at the end of blocks, in situations where we could prevent holding over somebody if we had that extra day. That would allow us to schedule more witnesses within a block and prevent holdovers from happening. It would be an extension of something the panel's already helpfully doing, which is when we're kind of just past 4 o'clock and we can extend a little to finish a witness, we do that. Thank you.
Thaçi Defense have something to say about the scheduling?
Just to, I guess, to respond to that and to follow up on Mr. Emerson's comment, we're content with the current schedule as has been circulated by the panel. The reality of the defense side, particularly in light of recent events, is that it is quite a challenge to prepare for the next set of witnesses, and we use the time that we have available to us outside of court to be able to be ready to go for the next set of witnesses. So the 3 weeks on, 2 weeks off, 3 1, 3 2 is a model that works for us, and I think fairly gives the defense an opportunity to catch up and to prepare for the next set of witnesses. So we would ask that that schedule be maintained. We may have some other ideas for how to expedite this, but if we're talking just about the schedule now, that's it.
Not much, Your Honour. As Mr. Emerson said, we don't want any change to this schedule. We don't, we are still playing catch up with respect to the evidence, and I understand that might be frustrating to hear, but that is the reality. We are preparing witnesses still on a witness by witness basis, and the fact that the prosecution has continued to call their case out of order does compound that problem. So we simply do ask that the calendar remains as it is to make this manageable and to ensure that our clients' rights are actually protected and we can do our job. Thank you.
Thank you very much.
Nothing further, nothing major to add beyond what my colleagues have said, but I'd like to point out that the Fridays during blocks are particularly important to us because we don't get to visit our clients after court and we don't get to see them at the weekends, and with the restrictions on visiting now, it can also be difficult for two teams to be there at the same time. So if the panel is minded to, perhaps on an exceptional basis, ever sit on a Friday, it would have to be only the last Friday right before a break, in our view, in the interest of fairness. Thank you, Your Honour.
I appreciate that, and we've talked about that eventuality also, or possibility, I should say. Mr. Ellis?
Your Honour, I think that is also our position. If on an exceptional basis it would assist to take an hour on the Friday to finish a witness, then that's one thing. But for it to be a regular sitting all day Friday, that would take up the time that we need to take instructions from our client.
Yes, and we need that time too, because you all file an enormous amount of documents, and sooner or later we have to get to them and answer them in a reasonable period of time. And those Fridays are important for that, as are the weeks where we're not sitting in the courtroom.
Exactly.
So that's what we struggle with, day to day. I would like to solve the problem of losing Thursdays, though, when we lose quite a few Thursdays to court maintenance. And I don't know yet that it can be avoided, but that's one of the things we want to look into, and we promise you we will look into that and at least get those days back for us. We have a bit of a break right now also in that trial panel 2 is not going to be sitting in the courtroom as often this next few months as they were up till now and as they will be perhaps soon. But so we do have a little extra wiggle room if we need to add a day or finish a witness. It's possible. Yes, go ahead.
Before we leave that agenda item, may I just say on behalf of the victims in this case that we would support any move to increase the number of sitting days and of sitting weeks. We hear what Your Honour says, of course, about the importance of Fridays and what they mean in terms of the ability of the panel to process the large number of filings that there are in this case. But there are bigger gaps, perhaps, than we were all expecting, and we would support what Mr. Halling has said about that. It really comes down to this, that the more sitting days there are, the more witnesses can be called, and the more witnesses that are called, the happier the victims in this case are going to be. Not least because the victims are included among their number, many of them, the dual status witnesses. So we appreciate that there are many other considerations, but we wanted to put on record what we see as the considerations that affect our clients most directly, and that is that we would invite the court to sit as often as it can.
Thank you for the contribution. Unless there's some other comment on this general scheduling, I'll move on. No hands are up. This next part is basically for the SBO. Well, we're almost up to a year in this case, and back when we started, you estimated, I don't know if it was you, Mr. Halling, or somebody estimated that we might be finished in April of 2025. Is that still a firm date? Or is that, let me not say still, is that a firm date?
Yes, Your Honor. And this question, actually, the agenda item has multiple subparts. Would you like me to answer them kind of all globally at once, or to go subpart by subpart?
I'd rather go subpart by subpart, if you don't mind.
Sure. With that in mind, we'll give a little bit longer answer on the first question, but it will make subsequent ones shorter. There remains a path to hit the April 2025 target date, which was ordered by the panel, as I understand, on 15 February 2023. It is going to require further streamlining on our part and further accelerating in the courtroom. So on that 15 February 2023 date, I mean, the panel has to set this target date. It's a requirement of the rules. But at that moment in the trial, there were a lot of things that were unknown. And that complicated any estimate of the target, and there's certainly been some developments since then. Just to focus on a couple of these at the outset. First, on the same day that the target date was set by Your Honors, the trial panel was discussing the sitting schedule as it was then calendared for 2023. And the trial panel indicated, and I'm quoting now from the transcript, "The schedule we have provided to the parties and participants totals a bit less than 600 hours in the first year of trial." And that's on page 1912 of the transcript. Going off the periodic time reports provided by the registry, in the first 10 months of this trial, the total examination time up until the beginning of the current block was only 308 hours. And no matter how you contextualize that number, at the end, there's still been a lot fewer hours available for the SPO to present its case in the first year than was anticipated. The second point that I wanted to flag at the outset is at the moment that that target date was set, it's recalled that the defense had only produced provisional cross-examination estimates for the first 12 witnesses. You may remember that a lot of them were actually blank at the time, and there was subsequent discussion and even a little bit of litigation leading ultimately to a decision in early March 2023 where the panel found that 3 defense teams had not fully complied with that order. Without accurate estimates at that moment, it was understandably very difficult, frankly impossible, to set a forecast with a degree of accuracy. There's also been a lot of procedural discussions in the courtroom in the first year of trial that have eaten up a lot of available time. And some of them are necessary to set applicable procedures. Some of them are not. There was a recent discussion about the definition of a witness statement that has been canvassed many times before in this trial that may be a recent example of that. All said, this is the combined effect of all this is that over the first 10 months of trial, the SPO has used 100 hours in direct examination, again off the registry reported numbers. So that means we're only getting an average of about 10 actual hours, 2 hearing days of direct examination per month. And that was not something that could have been anticipated, and it makes very clear that we need to accelerate the pace. And we would just ask that this be kept in mind when considering the firmness of the current target date. And as I said, we can give answers to the subsequent questions about that date in turn.
Did you have a question?
I have a couple of questions for you, Mr. Halling. One thing is to follow up on a comment made by Ms. O'Reilly, namely the fact that you might, in some respects, have called your case out of orders. One witness in relation to one location, one witness in relation to another, one witness pertaining to the chain of command, and so on and so forth. Now, have you given consideration to the possibility of trying to do less of that and to consolidate substance-wise, if I can put it that way, a bit more, which might in turn, and that might be the underlying idea of Ms. O'Reilly, or at least that's mine, enable you to make an assessment in relation to specific incidents, to specific locations, to specific issues in your case, whether there's a need for further evidence. I do share for myself the concern of Ms. O'Reilly that it makes it very difficult, not just for the defense, but for us, the judges, sometimes to go back to a part of the case that we haven't heard of in weeks and sometimes months. And wouldn't it be one of the ideas for you to try to accelerate the pace of your case and at some stage perhaps decide not to call all of the evidence that you currently have on your list?
Thank you, Your Honor. It cuts both ways a little bit, Your Honor's question, because calling a broad cross-section of evidence across different sites allows us to get also an earlier read of what may be cumulative later in the case. So if we if we schedule all of our witnesses for a particular site at once, and we realize after the first two that the next three are cumulative, we may not be able to physically reschedule new people into their spots because they're all lined up right in a row. And so actually having some breaks in the first year of trial, we're actually hoping is going to help our streamlining, that we can take some advancements forward on our crime sites across a great many of them to be able to knock out duplicative witnesses later. That said, we do appreciate that there may be situations where this causes the need for extra time, and we certainly are mindful when scheduling witnesses, and we're going to need to be even more so in the year to come, that we need to schedule witnesses in time so that they can be properly prepared, discussed in court, and efficiently examined. And on this level, I guess we have sympathy as well. We need to further streamline our case down, and we can talk about that under other sub-questions.
Thank you.
Yeah, go ahead.
Mr. Hanning, just to put a little more bluntly, I think, what Judge Metro was hinting at, is there a particular reason why you can't call your key witnesses sooner? Would it not make more sense for the panel to hear your key witnesses sooner rather than later?
It does make sense, and some of them have already been called. There are others that have not been called yet for reasons that we didn't want. One major issue in this trial that we wanted to stress in this agenda item is the obstruction against witnesses in this case. It has caused a lot of distortive effects. It has caused us to move witnesses out of order that we didn't want. It's caused us to do additional disclosures. It's caused us to divert resources up into and including having a trial in case 10, case 11 on further obstruction-related offenses. So there's also some issues of availability with key witnesses as well, that we aren't able to line them all up in a row. But in general, and we've said this before, we want to prioritize our more important witnesses earlier in the case, and to some extent that has happened, and to some extent that it hasn't. And we believe we have key witnesses coming up in the coming months, and we want to try and get them in front of your honors as quickly as we can.
So obviously, you've been, as I averaged it, maybe my math is faulty, it probably was on the 600 hours. It's been taking about 7 hours per witness on average for the 308 hours that have been used. At 7 hours per witness in the next year, you cannot possibly call the balance of your 300 witnesses. So how many witnesses do you now expect to call?
The current number that left to call right now is 144, I believe, if you include Viva Voce and Rule 154. The exact number that we're shooting for, we don't have an exact number. We're shooting for an hour's estimate in order to hit April 2025. But we can readily acknowledge that's too many witnesses. We can't call them all in that time. And we talk about accelerating the pace of the hearings and sitting more often and sitting better on the days that we sit. But some of this really is on us. And we fully recognize that we need to be expeditious and accountable at every step of our case, and that we need to streamline this down further. We have cut about 55 hours off our case since June 2023. Streamlining opportunities, we do it for kind of what I was saying before. We would expect them to be increasing in the year to come. It's just natural that the higher volume of evidence that's admitted, the more responsible streamlining decisions that you can make. And it is our hope and expectation that if we do further streamlining, it's not just cutting witnesses, it's also reducing examination hours for remaining ones, that's going to improve that average of 7 hours. But a lot of that 7 hours is for questioning other than us. So there's, of course, a limit to this that's beyond our control.
Yeah, of course. Question?
Just to follow up on that, you've told us you started with 600, you've done about 100. Are you still at 500 for the remainder of your case? Is that the hope?
I don't remember the exact number of hours if you stop the case as of this moment. It goes beyond April 2025. It's not 500, but it is still too many. And so what we are hoping to do is to have basically a two-pronged acceleration. We need to shorten the hours on the back end of our case so it finishes faster. And we're hoping to accelerate the progress of the hearing at the same time. And that the combination of that is going to allow us to clear more hours per month and shorten our case. So we don't have like a set number of hours that we need to hit in order to finish the case in April 2025. The pace of the hours we're also hoping is going to improve because of some of the measures that we're going to talk about later in the agenda about efficiency of the hearing.
So at the present time, you're without holding you to an exact number, about 145 witnesses.
144 now with 498 finishing yesterday.
And you haven't finished streamlining yet. I mean, that's your present total.
Right, yeah, and so again, and it goes to Judge Matro's question, the number of hours now is a snapshot that no one wants. We are not going to stay at that number, and we don't intend to. We need to keep streamlining the case down. Like I said, it's been 55 hours since June of last year, and we're expecting to do another round of streamlining. I think May is probably the next time we would be able to do the round. Every witness that finishes creates an opportunity to reassess others. We're looking also for opportunities beyond witnesses finishing. So one example would be, we've recently started filing motions with an intent to get adjudicated facts admitted from the Mustafa case in this trial. Were that to be done, we think there would be further Rule 153 opportunities for some witnesses relevant to that case. That's another example.
Anything else you want to bring to our attention, Mr. Helling, in this part of the discussion?
I think we've basically covered everything that we need to say to contextualize the date. I don't know if we've given a clear answer to the last question on the agenda, which is on confirming the date for the SPO to rest its case. As may be clear, we are not conceding that we can't make the April 2025 date. We're not guaranteeing it either. What I can say is that's the only date that we are working off of at the moment.
Yeah.
We are 10 months into the case. There's over a year remaining to get to the target. We're going to do our part to work towards it.
Thank you. Let me ask on what we just now discussed. Thaçi defense have any comments?
Yes, Your Honor. Let me start out by saying I want this to be a constructive hearing and not to devolve into an adversarial procedure. So with that caveat, I will say that we obviously dispute the comment about the relevance of an argument about a definition of a witness statement. You don't need to hear the arguments about it anymore, but that's the first point. The second is the introduction of witness interference into this discussion, we think is hotly disputed. I'm not going to get into it in public session here. If you invite me to hear more argument about why we think that's wrong, I'm happy to do it, but I'm trying to keep this conversation constructive. Let me just say, though, on that point, that we disagreed to use that as a reason in answer to Judge Gaynor's question of why we're not hearing more important, more relevant witnesses to the case against the specific accused. One such allegedly interfered with witness was called rather quickly and has already testified before the panel. We don't understand why others can't, but I'm prepared to make submissions in a private session if that really is an issue that needs to be debated. In terms of speeding this up, we have some suggestions, but we do actually, Judge Gaynor anticipated what our point was going to be, which is we think that this should be, the witnesses more relevant to these particular accused should be moved up It would potentially expedite things, not only because you'd be hearing more relevant witnesses, but it may open the door to, certainly from the Thaçi defense, to a conversation with the prosecution about the need to call more crime-based witnesses, and the potential for agreement on, potentially, and this is just a brainstorming idea, but what they would propose to get out of those witnesses in direct, and see if they would agree to what we would propose in cross, and avoid the need to have to call some of the crime-based witnesses as a means of speeding up and reducing the number of witnesses that have to be called. Another proposal we would have, frankly, is we think that more status conferences like this should be held. We think it provides an incentive to all parties, particularly the SPO, to stay on track and to stay motivated to continue to review their cases, and I don't mean that as a slight to the prosecution. I think it's a natural human tendency to deal with what's in front of you. And the more of these we have, whether they're monthly, I think it'll help everybody move this case along more quickly. So if it sacrifices an hour or even adds an hour like this at the end of a day, so that actually we don't lose any courtroom time, I think it would be very useful for the panel to schedule those on a monthly basis, and we take stock of where we are. Thank you.
Thank you. Ms. O'Reilly?
I would tend to agree that a lot of this is about making sure the case is organised properly. And certainly at the ICTY, we used to have regular housekeeping sessions that were really quite helpful in terms of keeping the trial on track. So I definitely support that. As regards the proposal to discuss the crime base with the prosecution, the Thaçi defence would also be willing to enter into that discussion. As you will have noticed, we're not cross-examining on quite a bit of the crime base. So we do think there is room for agreement there, depending, of course, on our colleagues behind us. What is not appropriate is additional use of Rule 153. We have a right to cross-examine witnesses. We don't, push for them to call witnesses that we have no intention of cross-examining. And as I said, we're willing to discuss that. But that is a rule of admission that's supposed to be used on an exceptional basis, and it should remain as such in order to protect our clients' rights. As for witness availability, I won't get into the allegations about how allegations of witness interference might be affecting that, but I would say that quite often we're told that a witness can't come because of their availability, and nothing further is said about that. We don't know whether it's witness interference or some other cause, but our clients have been in detention for 3 years. It's not unreasonable to inconvenience a witness to make them come here when their presence is required. So I would just ask that the prosecution is a bit more mindful of that, and perhaps the panel is a bit stricter on that, and that could maybe help get us witnesses in the right order, and would provide more organisation for this case. And finally, I'm sure your honours will have noticed that you haven't actually had any specifics from the prosecution so far today. It does sort of bring back memories of status conferences that we had for 2 years before we went to trial. And I would kindly request that some deadlines are placed on the prosecution to give concrete answers for the questions you've posed to them today. Thank you.
Suggestion about meeting periodically and trying to come up with what I will call a 153 type arrangement for a witness that maybe is non-controversial. Is that something the prosecution would legitimately be interested in?
Yes, it helps to do it outside the standard hearing schedule, like the current hearing. The only thing that we would say, we have tried and tried with agreed facts proposals in this case, and agreements to law. And we've heard this kind of receptive language before, and then nothing gets agreed to. I think it is.
I'm just asking you if you are willing to.
Of course we are. We always are. But there is definitely seems to be some parts of this case that are either lightly contested and uncontested. And if that could be channeled into further agreements, we could go faster.
Well, I will be very frank, and probably everybody in this room, including the panel maybe at sometimes, has delved into minutia when it really wasn't necessary in a direct or cross-examination mode. Things that are unimportant to the final outcome of the case. And I don't like to interfere, especially from the way I became a lawyer, interfere with the prosecution or the defense on how you go forward with this. But we have to concentrate on important issues, issues that are relevant to the decision that has to be made in this case. And I'm not going to come up with examples, but you all know that you've sat and listened to questions and you've thought, why on earth is that person asking that question? What does that have to do with anything? And I suggest that we try to avoid that. And I also think it's a great idea that you meet periodically. I'm not going to order you to do it, but you both have to go into that kind of a meeting with a cooperative spirit and think that you're trying to work something out for the benefit of everybody, including the accused, who are sitting and waiting for a decision in this case while they are in detention. So think about that, and I strongly suggest that you try to do that. Yes, go ahead.
Interpreter's note, we apologize, but we need a few seconds to catch up with interpretation.
My fault.
Mr. Mišetić and Ms.
No, they want to wait a minute.
I want to take you to task, Mr. Mišetić, on something you've said, and Ms. O'Reilly as well, is your willingness to discuss with the SBO crime base. I want as candid an answer as you can give us in terms of whether that's realistic. And I'm just going to cite a few facts. The first is the attempt that were made to have a set of agreed facts led close to nowhere in terms of facts of relevance to expediting the process. The second thing that I would highlight in my question is the resistance by the defense almost systematically to 153 and 154 statements, including and in particular in relation to crime-based witnesses. The third issue that was also part of Judge Smith's comment a second ago was the fact that your team, Mr. Mišetić, spent close to 100 hours cross-examining witnesses, many and most of which were crime-based witnesses. So is it really realistic that are we looking at a new approach by the defense in relation to these issues? Will there be less cross-examination of crime-based witnesses? Will there be more engagement with 153, 154 application in relation to these sorts of witnesses? Or is that, in French we say un vœu pieux, a hope that somehow this will happen?
Well, I do wish to emphasize a second point of what I said, which I would ask that you keep in mind. My proposal was not simply that we agree to crime-based witnesses. It would have to be a mutual approach where they agree to the points we would make under cross-examination. And so it's not just as simple as saying, here is a list of facts that a crime-based witness would testify about, and you concede the point. What I'm proposing, and that's why we don't automatically agree to 153 and 154, usually, and I didn't write all of the responses or many of them, but it's because we have a point we want to make in cross-examination. If the prosecution is willing to indicate in inter partes communications that they'll concede those points on cross in exchange for us conceding certain points they wish to make, and I'm using a hypothetical here, but if we go through the pretrial brief and they cited that witness for this proposition and we say to them in exchange we want you to agree that on cross-examination the witness would concede this point, et cetera, then there would be some ground to not need to call the witness on that point. I can see there's problems with, for example, if we want to call a witness to cross-examine on the basis of a credibility challenge, then I doubt that the prosecution is going to concede that the witness is not credible. But if it's just affirmative facts that we want to establish through a witness, at the very least, it could shorten what needs to be cross-examined during the hearing. But that's my proposal. That's the reason we always, in good faith, ask to cross-examine witnesses. And if we can reach some agreement, particularly because, and I need to emphasize this point, and emphasize this point on behalf of my client, we need to finish the prosecution case by April of 2025. We have a lot of reasons that I could get into on the Thaçi defense, but this is not an unlimited ability to endlessly litigate for years on end, and I mean that in a staffing and resources and et cetera. So we have a fundamental interest, not only because they're in detention, but because the effectiveness of the defense depends on this prosecution case finishing and the defense, which we, having consulted with my colleagues, think we can put on a defense efficiently and wrap this up so that they have a quality defense by the time you get this for your deliberations. In that spirit, what I'm suggesting to you is we should have communications, and without posturing by any side of, you know, my witness is great or we kill your witness on cross-examination, but just to say, look, you can make these points through the witness, we wanted to make these points through the witness, and let's see if there's a way we can avoid having to call them.
I would like to see some positive results on this issue. I think that's the way forward for us.
Let me just say, though, I will say that it's really up to the prosecution to approach us because they decide who they want to be in front of the court, and then
I
we
agree
can
with
respond.
you about that.
Yeah.
I personally agree with you about that. I think the prosecution's leading this case at this point, and they need to bring that to your attention and to come request some a conference on it. We'll come back to the defense and cross-examination in a little bit.
May I just quickly respond? Sorry, as Judge Matteo
Well, I haven't
had
asked
asked
Mr.
me to.
Roberts and Mr. Ellis yet for their comments, but go ahead.
Well, just to point out that there is a difference between 153 and agreed facts and 153 witnesses that we want to cross-examine. There are a number of 153 witnesses that we have agreed inter partes that they can go in via 153. That does not amount to us agreeing to the contents of their testimony as truth. There is also the fact that 1 year ago, we knew almost nothing about the case because of the extent of the redactions. We do now know more. We're still sort of playing catch up. But I do believe that that provides us with room to make more decisions on what we're challenging and what we're not challenging. So I do think there is scope for further agreement on this. And I would also support Mr. Luca's proposals on behalf of Mr. Thaçi for us being permitted to put in some documents on the cross-examination that we would have maybe done for 153 witnesses to allow a more full assessment of those witnesses. Thank you.
Mr. Tully.
I don't have anything substantive to add, just to support the idea for regular status conferences and the proposal for the procedure of inter partes discussions about witnesses. Thank you.
Mr. Ellis.
Yes, Your Honour, we would echo that position. We have been trying to do the maths on the number of hours left in the prosecution case, and I think it's still quite alarming. Sitting more weeks for us is not the answer because we are still playing catch-up for the reasons explained by our colleagues. But if there are going to be witnesses who are dropped by the prosecution, it would be helpful to know that earlier rather than later. We don't want a situation where we get to this point next year and we're suddenly hit by an avalanche of 153 applications and dropped witnesses. If there are witnesses being dropped, obviously the defence may want to speak to those witnesses, and currently the contact protocol would stand in the way of that. So the earlier we can have notice, the better, and status conferences would certainly help that.
We want to discuss the publicity of proceedings, and we continue to seek ways, as I said in the agenda, to increase the public trial aspects of this case. And we are really interested in your comments, and some of your comments have already been put into place and are having some effect. Using codes does work. I think we've proven that it worked, but it seems to have fallen by the wayside. We used some the other day, not really codes, but we came up with an agreement on the use of relationships rather than names. I would strongly suspect that we can do a lot of good by using codes and avoid a lot of private hearings and have more public hearings. And the second thing is the public redacted transcripts. They're coming in, they're being done, but we need to keep the speed up as much as possible, get them finished. And when you file an application, make sure you file the public redacted version as well, so that we can continue without having to go through unnecessary motions and demands on our part. Comments on this?
We can give brief ones in relation to what
Yeah,
Your
so
Honor's
go
just
ahead,
said.
yeah.
In relation to codes, yeah, we did try and do this yesterday, so we are still looking for these opportunities. The only thing that I would say is to codes for maybe some witnesses where it hasn't been done. Not every witness is able to consistently respect that kind of a code arrangement. And as Your Honors know, every time a redaction order is imposed, it's not just the individual line that's cut from broadcast, it's sort of a range around that line. And if you do that enough, you've effectively recreated private session. So it doesn't always work. There's also some witnesses where, because of interference or other reasons, the stakes are so high that them being identified even with a redaction order attached to an open session may influence our decision to proceed without codes. But we are looking for this, and we do think it's a good solution. On the transcripts, we're following all of the deadlines. We can say that we're very close to clearing the backlog from last year of all the witnesses that have testified so far. We did a filing, I think it was 14 witnesses that went to the trial panel recently. So this has been proceeding, and we've been satisfied with it. We would just note in this regard that the defense has actually objected to very few redactions that we have proposed so far, which is sort of helping to further get this resolved more quickly. And also, this is always true, even when redactions need to be maintained to private session testimony, it will be common that the confidential evidence can still be referenced publicly when doing so doesn't defeat the purpose of the confidential classification. And this is already memorialized in paragraph 4 of Your Honor's conduct of proceedings. Thank you.
Anything?
Your Honor, I don't have anything to add.
Okay.
We obviously want to make it as public as possible, but we can just.
Well, I think sometimes we get a little far afield on the associations with the witness. In other words, whether we can use him or her, for example. I understand every once in a while it's important that we avoid that, but many times it's not really necessary. And we need to avoid those kind of very remote possibilities of any kind of contact. The whole purpose of having a number for the witness is so that you can use that number, not so that you have to use some other number to reference to that number. That seems to be very difficult.
Yes, no, we fully understand, and in that regard, we have asked for that gender-neutral language a lot less frequently for recent witnesses. Yeah.
But anyway, those kind, I was using that as an example. That's an example of a far-reaching or excessive reaching for the conflict. But understanding that it's sometimes necessary, given a particular circumstance. Yes, go ahead. Do you have a question?
I have an idea, Mr. Halling, and I want to hear from you whether that's a good one or a terrible one. On a number of occasions, we've maintained the confidential nature of something which is otherwise a public document. Let's say a press article or a document otherwise available in the public domain. We would be the only place where that information is confidential. The logic of your request and the basis on which confidentiality was maintained is the content of the document could, if associated with its number, lead to the identification of the witness. That we understand. Now, would a solution whereby these specific documents are given a mere number, let's say instead of being Exhibit 737, we give another number that is 2,402, which can't be associated to the witness, would this enable us, in our judgment in particular, to use public documents in a public way?
Yes. I think, Your Honor, solution is the kind of thing that would need to be done. In these situations, it's not the document itself that's the problem. It's the metadata around the document. And so giving it an exhibit number that moves it out of order, or perhaps referencing certain documents only by their electronic registration number, which is not indexed to a part of the proceedings, but is a number that's sort of pre-stamped before the trial starts. There may be measures like this where the metadata can be disguised that would then allow a public document to be referenced publicly. But Your Honor understands the reason why these things have confidential classifications, and we do think that this could help in solving that.
Any comment on that possibility by the defense? Anybody?
Again, we would support anything that that makes the proceedings more public, and it actually touches upon a problem, a concern we do have, which is how this judgment is going to be public and how it can be subjected to scrutiny when so much of it is going to be confidential.
The only thing we haven't done is we haven't talked about this concept with CMU, because they're going to have to keep track then of two different lines of the exhibits in effect. So that has to be a solution that we can live with. Okay. Now we need to discuss a little bit with the cross-examination end of... Oh, I'm sorry.
so sorry.
I'm sorry, I didn't see you, Mr. Laws.
Yes, if I may, I thought just to say, on behalf of those in my team who are working very hard to keep up with the transcripts and with the redaction process, just to give you some idea about what that involves, a recent witness who testified for 5 days, it took 5 days to do the redactions, which you're going to see very shortly, but it's been an enormous job of work. And so those involved in that who saw this agenda and saw that the speed of the process had to be improved, rather hoped that I would say something on their behalf about how difficult that would be, in fact. So having made that submission, we just ask you to bear that in mind when you consider shortening any deadlines or doing anything of that kind. It's a very laborious process, and it's much more difficult than it seems from the outside, where you've got a range of different factors and variables which could identify a witness, and a lot of thought goes into it.
Thank you. I think as long as we can keep up with the schedule that we adopted back in, I think it was February or anyway, I can't remember when it was that we adopted the schedule for redacting, as long as we can keep up with that and get rid of the backlog and stay more or less current with the new issues, I think everybody can live with that. But it's really important to get that public redacted version out there so that people can at least read through with some degree of accuracy what's going on here. And I appreciate everybody's efforts on that behalf. So now a discussion on limits of cross-examination, just on the concept. We're not proposing something yet, we're just talking about what could be done and the reason why. And I can just state that instead of focusing on facts and circumstances material to this case, cross-examination has many times, I first wrote frequently, but that's not really true, but many times, has focused on issues only remotely relevant to this case. Also, the questioning sometimes has been highly repetitive in respect of some of the issues explored. However, there has been improvement recently, and I appreciate very much the fact that you, on the defense end, sometimes get together and decide that one person will carry the largest part of the burden and everybody else can ride along and ask those important questions that they have in addition. But the panel has a duty to ensure that the trial is fair and expeditious, as you know, and we have the power under Rule 143.4 to inter alia control the mode of questioning of witnesses so as to make the questioning effective for the ascertainment of the truth and to avoid repetition and undue consumption of time and resources. The panel has already indicated that a trial will only be expeditious if all those involved contribute to achieving that goal. The panel believes that shorter and more focused cross-examinations are necessary to achieve that goal. And now Judge Gaynor had some questions. I just wanted to make that general statement, and he has some more pointed questions about it. Go ahead, Judge Gaynor.
Thank you very much, Judge Smith. Approximately 58% of the total courtroom time used until the start of this week in questioning prosecution witnesses, that is to say 179 hours out of 308 hours, has been spent on cross-examination by the defence. The panel has allowed the SPO to make extensive use of time-saving measures, such as Rule 154, and recognises that there is no easy arithmetical relationship between the duration of direct examination and the duration of cross-examination of Rule 154 witnesses, in particular those who have previously given extensive evidence. And if a prosecution witness has been evasive in their testimony, that can require somewhat lengthier cross-examination. Taking all this into account, we would like to hear your comments on the following proposal. The panel might inform the parties and participants of the time limit for total defence cross-examination of each prosecution witness sufficiently in advance of the commencement of direct examination of that witness. The following factors would be taken into account. First, the SPO estimate for direct examination. Second, the time estimates by the defence for cross-examination. Third, the scope and complexity of the evidence expected to be given by the witness, and in particular, whether the witness is expected to give evidence of the acts and conduct of any of the accused. Fourth, where the witness is a Rule 154 witness, the total volume of prior evidence of the witness and associated exhibits to be tendered by the SPO. Fifth, whether the proposed Rule 154 material includes a transcript of cross-examination of the witness in prior proceedings. The defence teams would then be at liberty to divide that time allocation for cross-examination among all defence teams. Any defence team, at the conclusion of the overall time limit for cross-examination of a particular witness, would then be at liberty to apply for further time, identifying with specificity other areas of relevant cross-examination and explaining why the defence has not yet cross-examined on those other areas. We would now like to invite your comments on this proposal. Could I start with the Thaçi defence, please?
Yes, that's quite a bit to go through on my feet here. So we would oppose the imposition of any restriction on the defense in terms of time limits. If the panel, and in particular the presiding judge, feels that we're being repetitive or not focusing on any relevant topics, we would more prefer that the presiding judge simply tell us to move on or grant a objection on the basis of asked and answered or something like that, and we can move on. I'm reluctant to get into even more litigation before trial of all these factors and then us having to come back and make arguments about what the appropriate amount of examination time is. In particular, because the whole process of giving you estimates thus far has been somewhat of a moving target for numerous reasons on trying to predict exactly how much time you're going to take in cross-examination. Some witnesses are obvious. I can tell you right now off the top of my head, I'm going to need a lot of time with certain witnesses that are on the list. Others are difficult to foresee because either they're extremely combative on either direct examination or cross-examination, or there was a witness earlier in this trial, and I'm thinking of Mr. Mustafa, who gave very short, concise answers, and my cross-examination went much faster than I thought it was going to take. So from our position, the Rule 154 material is in effect a direct examination of the witness. We have to cross-examine on, I would say in response to that, if everything is coming in under Rule 154, if transcripts from other proceedings are coming in under 154, we have to assume that all of it is being offered because it's relevant the prosecution thinks it's relevant to proving their charges against the accused. And we're going to cross-examine on anything that's in the statement that could be relevant to the prosecution case. So to us, the first step should be that the panel has the authority to reduce the amount of prosecution witnesses in the case rather than put the burden on the defense to limit its cross-examination. We think that's the first step. Again, if there is any unneeded cross-examination, et cetera, I think the panel already has the power to tell us to move on or to focus on different issues, and I'm sure all of us would be more than satisfied to hear if a topic is not of a particular interest to the panel, then there's no point in us going through the exercise of needlessly wasting time in cross-examination. So, however, if that is the proposal, obviously we would have to deal with it, but we do think that it further reduces the ability of the accused to meet the case against him. I do want to raise a couple of other points that make it more difficult, and this is not a factor of this panel, but it is a factor of international criminal law, which is two things that have come up, including something that's come up today, which is when documents come in and they just come in, we can't not address them. So the fact that much more gets in than under a very, let's say, very liberal regime of evidence admission, it means we have to deal with it as if it could be used against us. And so that is a problem, is in our opinion, too much is getting in that is of little probative value, but nevertheless, it's in, so we have to deal with it. The second issue is the issue of judicial questions, which many times has added on more cross-examination by the defense. The idea of us not only having to anticipate what the prosecution is intending with certain evidence, but anticipating what the judges may ask or may be relying on independent of the prosecution case also adds to how many questions we ask and what we go into. So it's not a simple answer. I personally have tried, and I hope the panel has seen that, and I'm speaking for myself now only, to try to keep my cross-examinations within 3 hours or less, because I do think there is a point of diminishing returns in cross-examination, and we will attempt to achieve that. But as I've said in my earlier submissions, where we think there is a prosecution witness who is actually part of a case against our client specifically and is very direct link to our client specifically, we will take more time. With other witnesses, we'll take less time, and we would ask that you give us an opportunity to see if we can continue the process of reducing cross-examination time on our own without the imposition of limits. Not only because we don't think limits should be imposed, but also, frankly, adding more administrative burdens on us at this point is very difficult, and oftentimes, and I'll be blunt, if our deadline to give you a time estimate is too far before the witness comes, candidly, we probably haven't had a chance to even review the witness material, so we're always going to err on the side of caution and ask for more time than perhaps we'll ultimately wind up needing. So if you do impose the process, we think it should be much closer to the actual date of the witness's testimony than saying, a month or two out, give us an estimate. Thank you.
Thank you. The Vasari defense?
I think it goes without saying that any sort of process would have to be subject to challenge by the defence, and I fear that you would be creating a situation where we're generating more litigation because we are required to challenge the limits that the panel is attempting to impose. I would also like to make clear that any attempt to impose limits would have to be very specific and individualised, because you would be transgressing on the fundamental rights of the accused, and that's also within your duties as well as efficiency and so forth, and quite a serious matter. Having said that, we actually aren't opposed to time limits per se, but they would have to be reasonable and they would have to take into account these factors. Having said that, our cross-examination estimates haven't, in our view, been terribly problematic. our cross-examination times. There's been a few times where we have gone long, particularly in the last block. We had one witness who changed her evidence right before she came into court. That was an issue that arose out of the preparation sessions. That is another problem. The prosecution has been using them to take new statements, which affects our estimates and affects the complexity and, frankly, the stress levels of everybody involved in these proceedings. So, you know, that's another way in which these, this trial could be better organised, is if some further limits were imposed on the preparation sessions. But yeah, to summarise, I think it's going to be a very tricky thing to try to impose on us for legal reasons, but we are not completely unwilling to work with that.
Okay.
I will say that the few times, and it has happened a few times, that I've asked there to be I've said, could we get finished by such and such a time, in effect imposing a limit. Everyone's cooperated, and we've gotten through it without any trouble at all, and no objection. So it does happen, and it has happened in this trial. And I don't think we're, well, let's just leave it at that for now. So, Mr. Tully?
Well, Your Honour, I echo what Mr. Titch said about, and what Your Honour is saying about putting a limit on us at the moment, in the moment. So subjectively, if there's a moment, we're never opposed to being kindly shepherded to move on from a topic or to limit it to a certain time. But one of the issues, I believe Ms. O'Reilly referred to litigation that would happen, is that it's easy to look at us here as an amorphous blob of the defence, but we are 4 individual teams, and herding together, and I know that His Honour Judge Montreux would know that herding together defence teams to get to agree, even on points that are, well, it would seem uncontroversial from the outside, is difficult at the best of times. So getting us to what would effect turn into, at some point, not always, but a fight over hours, in the abstract in some kinds would be, in our respectful submission, a bad idea. But we're happy for the guiding hand of the judges to limit us in moments where you feel it's necessary. Thank you.
Thank you, Mr. Tully. Mr. Ellis?
Your Honour, first and clearly, we would oppose the setting of any overall time limit on the defence for cross-examination. I say that from the position in which we sit resolutely at the bottom of the league table in terms of hours used in cross. And I would therefore see no basis to impose any fetter on us. Additionally, a comparison between the SPO and the defence in terms of hours used in this case is inherently misleading because of the amount of 154 witnesses in the case. The prosecution's 100 hours of direct would be far longer if they had gone through all of the very lengthy statements that have been admitted through 154. But we have to cross-examine on all of that. And so I suspect what may look as though the defence are taking a long time in cross is wholly reflected by the prosecution saving its direct by putting in material through 154. I would say that despite that, we've had long direct examinations of 154 witnesses from the prosecution. For example, witness 4337, over 2 hours taken in direct of a 154 witness. Other examples would be 4448, 4408, 3165. There are witnesses where a lot of time is spent in the prosecution re-eliciting material that has gone in writing. Finally, just to echo the point made by others, if a procedure is imposed setting a time limit based on a consideration of factors, with the defence then having the opportunity to challenge that, that in itself is a time-consuming procedure which is going to impose a burden on the panel and on the parties to make the submissions, review the decision, and then challenge the decision. It's going to lead to satellite litigation that will delay rather than extend proceedings. I will say that I'm sure the panel feels able to tell me when I'm straying into an area that the panel doesn't feel helpful in cross-examination, and when that is said, we do our best to move on as much as we can.
Thank you. Thank you, Mr. Ellis. Go ahead, time for the prosecution.
Thank you, Your Honors. We fully support this kind of a proposal. We were actually going to propose a variation of the proposal of the panel. This case is not measured in direct examination hours, as is with trials at some other institutions. It's against a specific date in time of April 2025. That requires efficient behavior from all the parties in order to meet it. And we shouldn't have to lose witnesses important to our case because the defense is not prioritizing something that they've been repeatedly encouraged and even ordered to do by the panel. We appreciate that the panel can set limits within a witness as certain questions become repetitive and so on. We've tried that already. Paragraph 110 of the Conduct of Proceedings decision foreshadowed the possibility of setting limits like the ones being contemplated in the proposal now. And there have been inefficiencies in the defense's examination that have risen to a level that this really needs to be done. And the resistance to the proposal of the panel, including one submission from Ms. O'Reilly where she said, "We are required to challenge the limits that the panel is attempting to impose," is really a sign as to how much these limits are necessary in the first place. For WO4448, which to the presiding judge's point, this was an example from last November where the panel set a global cross-examination estimate for the defense teams for that witness. And it indeed happened, and there were no significant issues. This proposal is also going to help us with something that we have been talking about a lot in this trial, which is that it will make the defense's cross-examination estimates more accurate, which is going to help us significantly in scheduling our witnesses. This has been discussed before. And just to give one statistic to really convey the degree of inaccuracy that the estimates thus far have been, from comparing the initial defense written cross-examination estimates to what they have actually done in the courtroom, by our calculations, they are just over 247 hours off collectively in 10 months. That is 49 hearing days off. And a panel proposal that sets some objective requirements that can lead to an estimate that, again, can be extended upon good cause, we think would be worth doing at this juncture.
Mr. President, I'm sorry I have to rise because I thought the spirit was each of us to do what we thought we could do, and now we've gotten into argument which you specifically requested we not do. So I do ask for leave to respond to that.
Go ahead.
Okay.
Shortly.
First of all,
you have a time limit.
Thank you. So first of all, this issue about however many hours Mr. Halling mentioned, we know and you know full well that we haven't had empty days because the defense cross-examination estimates were off. It may have happened on a rare occasion, but that's not the issue here. Secondly, I don't want to relitigate what we said to you, Mr. Emerson said to you before the trial started, but we can give you chapter and verse of trials before international criminal tribunals comparable to this trial, or even bigger than this trial, where the prosecution and defense were able to put on their case in less than 2 years with no restrictions on cross-examination. The fact that we're engaging in this is because the prosecution refuses to give you specifics on, are you cutting your witnesses? They come to court, they say, boy, you know, we really know we got to cut this down, we got to streamline our case. Any specifics? No specifics. So here we are. But very specifically, you can cut the defense cross-examination time because that will make things more efficient.
To be fair, they did say we're going to go 145 witnesses.
Yeah, well.
That's a reduction. That's a huge reduction.
How is that a reduction?
Huh?
How is that a reduction?
Well, we started out with 320 and we've only done 45 and now we're down to 145.
Okay, but.
Oh, we've only done 45.
So how are we going to finish 145 witnesses by April? Well, their proposal so far, their only concrete proposal is cut the defense cross-examination
No, and to
time.
expand the hearing days.
Okay. Well.
You have to be fair, you know.
I'm going to be fair. There's no way they're going to finish 145 witnesses viva voce or in court by April of next year. So my only point is there are plenty of examples where a case comparable in size, right? Kosovo, a 2-year, actually, what would it be? A 15-month conflict. I don't want to relitigate everything we've said before, but let's not lose sight of the fact that we're here because in a case I participated in, which was very similar, where everything was done in 2.5 years, right? they're asking for triple the amount of time to put on their case, quadruple the amount of witnesses. That's the real issue here. So if we're going to drive this to some conclusion, it's not simply let's look to the defense and cut their time and continue with a 300 witness case, right? Okay, they've cut some witnesses, but they're just moving them through 153, 154, 155.
I can see why inter-party discussions become difficult. I mean, I asked at the very beginning to do just one thing, and both sides have violated that. We have to have some sort of inter-party connection with you. I don't expect you to sit and pat each other on the back, but we need to get some issues dealt with. And we aren't going to deal with them if we're constantly pointing the fingers at the other side. Everybody has had a hand in having delays. I guarantee you I've heard repetitive questions out of the defense, and I guarantee I've heard repetitive questions out of the SPO. Many times, many times. We walk out of here and say, why do we have to listen to the same question over and over and over again? Each lawyer asking it 3 or 4 times in order to get the answer that they want. That's not how this works. You ask the question, you get the answer. That's the question. That's the answer you got. You can ask it once in a while one more time because of some misunderstanding, but we can't go through this over and over again and get anywhere. That's the idea of repetitive questions getting in the way of resolving these cases. I guarantee you that that out of a 4.5-hour proposed cross-examination, you could find a half hour off and get rid of it, because just out of repetition alone. So, and that goes for everybody. I'm not trying to pick on any one side. I've heard the same thing from the prosecution. Why are they asking that again? They've already asked that question. Or why are they asking that exact question that was answered in the 154 application? Very often we're getting the questions that were in the 154 application asked again. What's the point of the 154 if we're going to ask the same questions in viva voce testimony rather than leaving it in the documents? So, well, I guarantee you we will have more status conferences, because that looks like something one of the things everyone can agree upon. I guarantee you that at times I'm going to suggest that the defense limit their cross-examination for certain particular reasons, and I'll try to elucidate them in some way. And I guarantee you that the SBO needs to govern themselves in asking useless questions when they have a 154 witness. It can be done. And 145 is not the final answer for you. I know you've said that. So by May 1st, I want to have a new estimate.
Your Honor, could we have that in the 3rd week of May? We're trying to do a significant assessment of our streamlining, and we can give a more complete proposal if it's a little deeper into the month.
May 21st.
Thank you.
Okay? And I expect a streamlining, not just we've managed to cut out 3 witnesses. That's not going to work.
Yes, we know we need to do something meaningful. It will also need to be done after that moment as well, and just to foreshadow. Yeah.
Yes, I agree with you about that. Anything else by anybody? Any other complaints? Something that you'd like to bring up that you've been... You can't complain about me. That's the only thing.
Okay.
I'm too old.
Fair. It's just a proposal. I'm not sure if it's going to work, but each time we get a new batch of witnesses, we get 154 proposals and separately documents for use in prior statements. And there's a lot of duplication there. I can envisage a way that you could roll those into one. Your Honours don't actually rule on our objections for the documents for use. That's fine, but we could have separate columns for our objection to those documents being admitted for 154 and then for their use, but just to avoid us having to do 2 sets of litigation every time there are new witnesses coming.
If you wish, you could put that in writing and submit it to everybody, and
Okay,
they could answer it.
Maybe do it via email with the SBO first
Okay,
to see.
all right.
Yeah.
Anybody else? Any other issue you want to bring up that we can listen to or possibly even solve?
You isolated complaints. We have no more, Your Honor.
Mr. Misitich?
Yes, I owe Judge Matro an answer, and I'm just pulling it up here. Judge Matro, on your earlier question, it is the 2004 case, and I misspoke. It is paragraphs 29 to 31. Thank you.
We'll have this transcript available to us soon. We'll go through it, put together the proposals that were presented, and we will get back to you as soon as possible with some idea of where we go, other than what I just said about status conferences. Apparently, it's difficult to call them a status conference because of the way the transcript, the testimony goes out. You have to wait 45 minutes to get to a status conference. Anyway, we'll call it what we can call it. Meetings are fine with me. So, thank you very much, everybody.
All rise.